We are now on the record. This is State versus Bryan Kohberger, CR 2922-2805. We're here for a hearing on the Gonsalves family's motion to appeal, amend, and or clarify amended dissemination order that was filed back on February 3rd, was delayed because the media sought some relief from the Idaho Supreme Court. There was a delay to find out what the Supreme Court was going to determine, which they did. And this morning we have the state represented by Mr. Thompson and Mr. Rudley. Mr. Kohberger is in the courtroom, represented by Ms. Taylor and Mr. Logsdon. And I believe Mr. Gray is here. There he is. Thank you, Mr. Gray.
Your Honor.
Okay, and I believe some of the family is participating, observing on Zoom. So before we get into the arguments, I want to address the Gonsalves family and all the families, really. Didn't really have an opportunity to do this at the arraignment. My heart does go out to the families. And the loss to your children is devastating and horrific. I mean, there's no dispute about that. I also want to acknowledge and apologize because at the arraignment I did stumble over a couple of the names, Kaylee's name and Zaina's name, and I want to explain that. I was up all night, really ill, probably food poisoning, and I was not at full potential. Probably also some emotion and nerves as I read those names. And I'm sorry. So that's my apology for that. I know some people were concerned about that, and I wanted to address it. I also wanted to explain a procedure at the arraignment that apparently drawn from the media that some people were confused when Mr. Kohberger declined to enter a plea. And I just wanted to clear that up because I didn't really see any explanation about that in the media. That is Mr. Kohberger's right. And under Rule 11A1 of the Idaho Criminal Rules, and this is a quote, if a defendant refuses to plead, the court must direct the entry of a plea of not guilty. That is not unusual. But reading the media, it seemed like somewhat mysterious. So I wanted to explain that, particularly to the media. It's a small issue, but it's somewhat, well, I think that I have an obligation, just as the media has an obligation, to help to educate the public about the processes that we are responsible to follow in the courtroom, and that's important for journalists. That's also important for the citizens. So, if you're curious about that, you can always find the criminal rules on the Idaho Supreme Court website, and it's very, very easy to read them and maybe get a better understanding. All right, so that's my speech for today. Mr. Gray, come on up. And
if you allow me just a minute or two to get sorted out here.
Take
Appreciate
your
it.
time.
Thank you.
Thank you, Mr. Gray.
Can I proceed, Your Honor?
Yes, go ahead. Thank you, Mr. Gray.
First, Your Honor, we'd like to thank you for apologizing to the victim's family. I think it was an emotional day for them, and they appreciate your apology. I know that they took that heartfelt.
Okay,
Thank you. I first want to start off with a procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall submitted a non-dissemination order. And in that order, it applied to the parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in it. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email, because for some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then on January 13th, there was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call to speak to all interested parties. The Zoom call occurred at 4 o'clock p.m. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense, it was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6. As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting, the state and the defense, and all attorneys for the witnesses. When she had that Zoom meeting, and I've requested the transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we could have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding.
We are now on the record. This is State versus Bryan Kohberger, CR 2922-2805. We're here for a hearing on the Gonsalves family's motion to appeal, amend, and or clarify amended dissemination order that was filed back on February 3rd, was delayed because the media sought some relief from the Idaho Supreme Court. There was a delay to find out what the Supreme Court was going to determine, which they did. And this morning we have the state represented by Mr. Thompson and Mr. Rudley. Mr. Kohberger is in the courtroom, represented by Ms. Taylor and Mr. Logsden. And I believe Mr. Gray is here. There he is. Thank you, Mr. Gray. Okay, and I believe some of the family is participating, observing on Zoom. So before we get into the arguments, I want to address the Gonsalves family and all the families, really. Didn't really have an opportunity to do this at the arraignment. My heart does go out to the families. And the loss to your children is devastating and horrific. I mean, there's no dispute about that. I also want to acknowledge and apologize because at the arraignment, I did stumble over a couple of the names, Kaylee's name and Zaina's name. And I want to explain that. I was up all night, really ill, probably food poisoning, and I was not at full potential. Probably also some emotion and nerves as I read those names. And I'm sorry. So that's my apology for that. I know some people were concerned about that, and I wanted to address it. I also wanted to explain a procedure at the arraignment that apparently drawn from the media that some people were confused when Mr. Kohberger declined to enter a plea. And I just wanted to clear that up because I didn't really see any explanation about that in the media. That is Mr. Kohberger's right. And under Rule 11A1 of the Idaho Criminal Rules, and this is a quote, if a defendant refuses to plead, the court must direct the entry of a plea of not guilty. That is not unusual. But reading the media, it seemed like somewhat mysterious. So I wanted to explain that, particularly to the media. It's a small issue, but it's somewhat, well, I think that I have an obligation, just as the media has an obligation, to help to educate the public about the processes that we are responsible to follow in the courtroom, and that's important for journalists. That's also important for the citizens. So, if you're curious about that, you can always find the criminal rules on the Idaho Supreme Court website, and it's very, very easy to read them and maybe get a better understanding. All right, so that's my speech for today. Mr. Gray, come on up. And
if you allow me just a minute or two to get sorted out here.
Take
Appreciate
your
it.
time.
Thank you.
Thank you, Mr. Gray.
Can I proceed, Your Honor?
Yes, go ahead. Thank you, Mr. Gray.
First, Your Honor, we'd like to thank you for apologizing to the victim's family. I think it was an emotional day for them, and they appreciate your apology. I know that they took that heartfelt.
Okay,
Thank you. I first want to start off with the procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall submitted a non-dissemination order. And in that order, it applied to the parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in it. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email, because for some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then on January 13th, there was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call to speak to all interested parties. The Zoom call occurred at 4 o'clock p.m. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense, it was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6. As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting. the state and the defense and all attorneys for the witnesses. When she had that Zoom meeting, and I've requested the transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we could have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding the victim's family and whether or not they were allowed to speak to the media based on the fact that she had said all interested parties as well in the initial non-dissemination order. I didn't receive any clarification. I was just instructed to go back to Idaho Rules of Professional Conduct 3.6, as well as I was told, and this is in quotes from her Zoom release, take their duties in utmost regard when conducting themselves and advising their clients. I took that as I should tell my clients to be quiet. She reiterated that again in the Zoom call by saying that I had ethical duties ascribed above in the Idaho Rules of Professional Conduct for commentary of Rule 3.6. And she reminded me later that lawyers have a responsibility in giving advice to their clients. I disagreed with Judge Marshall on almost every point during that meeting. As well as if I had known that we were going to be discussing the Idaho Rules of Professional Conduct and that issue, I would have prepared. But only having a 3-hour notice didn't allow me, and not knowing what the subject of the meeting was going to be, didn't allow me to address those issues at that time. Now, after the non-dissemination order in January 3rd and then the January 13th, 2023 meeting, the judge amended the non-dissemination order on January 18th. And she basically repeated the same order, except for she added the attorneys for any interested party in this case, including attorneys representing witnesses, victims, or victims' families, as well as parties to the above entitled action. So you can see the difference is that the first one dealt with parties to the case. The second one went way over the top, addressing all attorneys that might be associated with the case or any attorneys that might have an interested party in this case. So that's where we are today. I filed the motion based on that additional language. Now, I'd like to get into some of the issues here. It's very clear that I am not a party to the case and the victims' families are not a party to the case. That's very clear through all of the case law, as well as...
Can I interrupt you?
Yes.
There's no dispute about that.
Okay, then
your clients are not parties. The only parties of this case are the state and Mr. Kohberger. That's
okay.
That's clear in the case law with regard to any victims or victims' families. There are constitutional protections and statutory protections for victims and their families. And
I would agree.
That's well established.
So let's get into the actual non-dissemination order itself, how it addresses to me personally as the attorney for the victim's family. This non-dissemination order, of all of the cases and all of the motions that were filed, and referencing every case that was listed in this case, none of them apply to a victim's attorney, an attorney representing the victims. The Idaho v. Tapp case was an attorney speaking about a judge who he was in front of. The Good case was a defense attorney that spoke to the media. The Mezebov case was a defense attorney and a prosecutor. The Morrissey case was a defense attorney and a press conference. Barner v. Delahunty was an attorney and a judge, all parties to the case. Cutler was a defense attorney, U.S. v. Cutler. Zhao v. Slock was a defense attorney. Irwin v. Dowd were the prosecutor's actions and speaking to the media. Shepard v. Maxwell is a trial publicity regarding the prosecutor's actions prior to trial. None of those things apply to the victim's family or the victim's attorney in any way. Now, I do agree that the court has the power to control those that are parties to the case and that are involved in the case in some way. But we have to define that. What means involvement in the case? Part of that is that the judge referred to the Idaho Rules of Professional Conduct 3.6, trial publicity. She references that multiple times as the basis for her non-dissemination order in this case and how it might apply to me. If you'll read the first paragraph, a lawyer who participates or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. That is not me. It never has been me. It can't be me because I'm not involved in the litigation. She also says to...
Can I ask you a question about
Yep.
that? Because, I mean, I think the case law is quite clear that attorneys who are representing witnesses can be restricted to some degree, partly because they have access to particular information that should not be shared with the public. And if I'm recalling correctly, the state has suggested or has determined that your clients are witnesses potentially. So that's kind of the
And I can
issue
address that,
right
Your
there.
Honor.
Go ahead.
As part of that is that, let's just make it clear, the victim's family has never been involved in this investigation, ever, from the get-go. After Mr. Kohberger was indicted, we've received no information about anything regarding the prosecution, nothing. They wouldn't even tell us that a grand jury was being impaneled for Mr. Kohberger. They told us that there was a grand jury that was being impaneled, and common sense, we figured it out because he's the only guy in the county. But they wouldn't even relay that information. They haven't given us any information regarding the investigation of the case. But the most critical part of it is that the prosecution has never, ever interviewed the Gonzalez family. So how in the world would we ever be able to be witnesses in this case? And for what purpose would we be? If you're asking about for sentencing purposes, that's post-conviction. That's after he's been convicted on the case. Prior to trial, we're not any witnesses. And that falls into completely different statutes. That falls into the restitution statute. It falls into the victim statute. I just handled that matter in front of the Lori Vallow case, where the judge, I had a motion, the defense did not want the victim's family to appear. And so the judge had to make a determination whether they were immediate family, because it was the grandparents. Completely different statutes because that was post-conviction. And those witnesses were allowed in the courtroom and were involved in the sentencing aspect of it. Okay? So we are in a very, very different factual situation here. I'm not asking as a witness to the case, which witness to the case, they've never ever told us in any way how we would be witnesses in this case, other than the conjecture that we may have potentially. That's not good enough to stop the free speech of the victim's family as well as myself. The other thing is that if the victims can say whatever they want, they're into free speech and that's exempt, why would I not be allowed to say the same thing that they say?
Okay, well, my understanding is that your clients are not restricted in any way, never have been.
Well, and I'll give you an example.
I mean, is that true? Do you agree
It's
with
right.
that?
Well, I agree now, because that's not the tone of the Zoom meeting when we
Well,
had.
we're not talking about the
Okay.
tone. I'm talking about the language of the order.
Yes, the language of the order now, because any interested parties, I asked for clarification, now we understand that they can say whatever they want, and that's correct. But here's the problem. If they said, we think the judge is crazy, would I advise them against that? Absolutely.
Thank you.
But if I went and said, the family has said that they think the judge is crazy, there's nothing wrong with that. I'm repeating exactly what they said. Now, what comes into play is, for our purposes today, is what if I offer up my own opinion, right? Well, then I'm already governed by the Idaho Rules of Professional Conduct. And if I'm
glad you're acknowledging that.
No, well, every attorney is, Your Honor.
Yeah.
I mean, it's not.
Thank you.
Every attorney is. So the idea that I'm not, but every rule doesn't apply all the time. If I'm talking poorly about a judge, another rule might pop in. 8.3, I think, is what it is, or 8.1. If I'm saying other things that might affect things another way, then maybe the trial publicity. But the trial publicity I don't even think applies to me in this anyway, because if you look at it, it says it applies to a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. And it goes on, highlighted by Judge Marshall, then in paragraph 3. The rule sets forth a basic general prohibition about lawyers making statements that the lawyer knows or should know will have a substantial likelihood of materially prejudicing the adjudicated proceeding. And at the bottom of the paragraph, it says this: rule only applies to lawyers who are or who have been involved in the investigation or litigation of cases and their associates. If I'm not a party to the case, I can't be involved in the investigation or the litigation of this case in any way. So I would argue that the trial publicity rule of professional conduct does not apply to me as well.
Help me understand what you think you can't say that you've already been saying.
I have no idea. I have no idea where it came from.
You've been on the media and you've had interviews, so I'm kind of wondering how do you feel that you've been restrained in any way with this order?
I think you're not seeing what the point is. What the point is that the court has issued a non-dissemination order that restricts First Amendment rights, that is overly broad in almost every aspect of it. Anybody that's interested and they have an attorney, when an attorney who's walking down the street could offer up his opinion in any way, it also takes away from the idea, doesn't the court want victims' families to have representation, to guide them through the legal process? Wouldn't the court encourage that they could explain things, say, maybe advise them on what to say, what not to say? I mean, if you're taking my voice away, you're taking the voice away of everything. The other part of it is this, is that I'm absolutely blown away that the prosecution doesn't agree with me in this case. The reason being is that they are representing the victims, which in turn are the victims' families. And I have not seen a poorer line of communication in my 22 years of practicing than the prosecution's office and the Gonzalez family. And I think it stems from, initially we were critical of the investigation. They wanted to find the person who did this. That's normal emotions. And then from that point on, it has been, we are the enemy. And that's how we feel in this. And so me guiding them and them trying to limit my voice and helping them out in some way, and then throwing out a random idea that they may be potential witnesses when they've never ever interviewed them in any way, it's just an attempt to shut the attorney up and shut the family up, is what it is. Because if I'd come to you today and said, we've given 7 interviews, Your Honor, we may be witnesses in this case, we've done all of these things, it may be a different story. We haven't done anything. They haven't interviewed the entire family. So,
well, I don't know what's in all the investigation, obviously, and a lot of us don't know and probably won't know until the trial.
And the other thing,
well, let me just say this. I think one of the potential issues is this is potentially a death penalty case. Hasn't been noticed, but that is a potential. And the families of the victims certainly would be witnesses in that process of sentencing. Now,
post-conviction.
That is not post-conviction technically, is it? Well, if your goal is fair and impartial jury, right, that's the reason for the non-dissemination order. Well, after the conviction, that goes away. Well, it's also confidence in the process. So I have that job. I have a job of protecting and preserving the First Amendment and also the Sixth Amendment. And there is some balancing there. That is why lawyers who have access to information that is not accessible by the public have particular restrictions. That's what this whole case is about. I mean, this hearing is about.
And as an officer of the court, I can tell you we have zero access
Okay, so you're saying that the prosecutor's office has not shared information with your clients?
Regarding the facts of this case, no, they haven't.
Okay. All right.
How things occurred.
And everybody's going to have a chance to weigh in on this, and I just, you're helping me understand what the issues are, so thank you.
Well, so that's really the issue here. I mean, and this is an important ruling, because what you're doing is this has never happened before. Ever has it happened before that a Judge Marshall, has tried to silence the attorneys for victims. Never has it happened that I'm aware of.
Would you feel more comfortable if there was a more concrete description of what people could say and what they can't say?
I don't think you have the authority to, Your Honor.
Well, I think I do have the authority.
Well, my argument is that part of the argument is that.
In fact, I know I have the authority to do that.
Well, and the authority would be through the attempt to have a fair and impartial jury, that you can control people that are involved in the case, correct?
That's part of it.
And we're not involved in the case.
Okay. That's hard to accept.
Well, we're not witnesses in the case. We're not involved in the investigation. We're not involved in the litigation. I can't file any motions. I can't subpoena anybody. I can't cross-examine witnesses. I can't do anything. Well, so this idea that there's this loose idea that there may be, weighing that versus our freedom to speak, the First Amendment, is...
We're talking about your
That's right.
speech.
That's right.
Not your client's speech.
But that is my speech. That is part of it, though.
Well, in your memorandum, you are suggesting that you also have an independent position, that you are representing yourself.
I do.
That is distinctive from your responsibility to your clients.
That's why the motion is for amending or clarification, because there's the clients that have the free to speak. There's me repeating what they have to say. If they said we thought the judge was crazy, and I said the judge was crazy, I can't be. It doesn't violate the non-dissemination order, because I'm allowed to say that. And then there's my independent voice, where I said the judge is crazy. Yeah, I think the judge is crazy. That goes into another layer, right? Where it would be, Idaho rules of professional conduct would fall into play, and what I would be doing or what I couldn't do. Not the non-dissemination order, because we're not parties to the case. I'd be governed by the Idaho rules of professional conduct if I made those statements, those statements. And I may or may not fall under the trial publicity. I would argue that I don't, because I'm not a party to it. I'm not litigated it. I don't have any information on it. None of those things. So really, that's where the authority for me, for my voice, would come from the Idaho rules of professional conduct, if I did that. And if I made a statement that I thought didn't apply for trial publicity purposes, that would be an argument for another day. But it wouldn't be for a contempt of court for me, because I'm not a party to the case and I'm not involved in the case in any way. I'm just repeating what my clients say, or I'm just saying my own individual opinion, which doesn't, by the way, makes it absolutely unduly prejudicial. Because what if a guy is an Idaho bar member, is walking down the street, looks up, sees a television program where the Gonzalez family says, well, we thought the judge was crazy, right? And then all of a sudden, the media is outside and they interview him. They say, hey, you're an attorney here. What about the judge being crazy? Well, I've been in front of him 3 or 4 times, and I would agree with him. You're going to sanction him in contempt of court? You can't. Same as me, because I'm not a party to it. He's not a party to it. He might be governed by the Idaho rules of professional conduct by commenting on you, Your Honor, but it wouldn't be because of the judge's non-dissemination order. So how can it not apply to him, but it can apply to me? It can't.
Well, the case law suggests that because you represent potential witnesses, that you have access to information that may not or should not be shared with the public. That's what the case law says.
And I would argue this: what potential witnesses are we, number one, and what access to information do we have? Well, I think the defense has argued that we have some sort of access because the clients can tell me whatever they want to tell me, right? Well, that's free speech. They can say whatever they want to me, and I can go off and say whatever I want that they said. Because it's free speech. It's the First Amendment. So you can't, I mean, this non-dissemination order is so broad, none of the case law applies to people that are outside of the defense or the prosecution. That's the point of it. That's the whole point of a non-dissemination order, because they have access to it. They have access to the information. Victims' attorneys' families do not. And the idea that we may or may not be a potential witness is enough for your honor? I just can't see that, especially when there's no history of them ever being a witness. And to tell you the truth, the day after they filed that notice, or the day before they filed the notice that we may be potential witnesses, we had just gotten out of a meeting with the prosecutor's office, discussing whatever we could discuss, like our concerns, because that's all we do is go in and talk about our concerns, and they tell us we can't say anything, we can't say anything, we can't say anything. We'll get to it. When we walked out, nowhere in that meeting were we described as being witnesses in this case. But all of a sudden, the next day, they thought we might be, even though they've never interviewed us. So they're throwing stuff in the air that is not justified, and the idea that he thinks maybe might is not enough to regulate my free speech in this as the attorney for the victim's family, because that's what we are. We're not attorney for witnesses, we're attorney for the victim's family. And if the court has any other questions, I'd be more than happy.
I understand your position.
Great.
Thank you, Mr. Gray. So let me go to the state. I don't know if that's Mr. Thompson or Mr. Rudley.
Don't be me. Can I have 1 moment, Your Honor?
Certainly. Thank you.
If I may.
Yes, you may.
Mr. Rudley is actually going to be arguing on the motions themselves, but as attorneys, we have a duty of candor to the court. Mr. Gray has made representations to the court that at best are misleading and in many ways simply untrue. And I need to correct them for the record because the media is here. I do not want the public to come away with the impression that improprieties have occurred. First, Mr. Gray, on behalf of his clients, has propounded a number of questions to our office and to the investigators. We have answered the ones that we can. We have not shared ones that we are concerned that Mr. Gray or his clients would make public and compromise the integrity of the investigation. For him to say that we have provided no information is simply not true. Secondly, he claims that law enforcement has not interviewed his clients and that somehow that is the investigator's fault. In fact, from the very beginning, the investigators have attempted to interview his clients and Mr. Gray has not permitted it. So just for the record, I want to make sure that's clear. Thank you, Your Honor.
Thank you, Mr. Thompson. You'll be able to come back in after you hear the other arguments. Mr. Rudley, go ahead.
Thank you, Your Honor. In State v. Spencer, the Idaho Supreme Court noted that it is also the duty of the prosecutor to ensure the right to a fair and impartial trial. Under the dictates of Shepard v. Maxwell, the court has a duty to take affirmative steps to address the impacts that intense pretrial publicity can have on a case. As noted in Shepard, Nebraska Press Association versus Stewart, and their progeny, an order like the one in this case is an appropriate measure for addressing that duty of the court. As Mr. Logston's experts have noted, attorneys often have information about a case that may not be appropriate for dissemination in the press. Additionally, attorneys carry a greater weight when appearing on television. For instance, what might be easier for the parties to address is a juror that says, I've seen coverage on the case, but I don't always trust what I've seen on TV, and I can set that aside. What's more difficult is a juror that says, I've seen attorneys for the prosecution, attorneys for the defense, or attorneys for the victims on television talking about a critical aspect of the case. In the matter of Gentile versus State Bar of Nevada, that case involved an attorney who held one press conference in 1991 after the indictment of his client. In this case, Mr. Gray's repeatedly issued statements and been on television. At minimum, it's insincere to argue that he's feeling bound by the order when it's clearly not abided by. In Gentile, the court noted that the speech of attorneys is subject to less substantial, or it can be regulated by less substantial means. In this case, as we've shown by the affidavit we filed, the Gonsalves families are potential witnesses in a trial, or more specifically at sentencing. The order in this case is not vague, overbroad, unduly restrictive, or not narrowly drawn. It precludes all extrajudicial statements of the attorneys in this case, attorneys for the witnesses, victims, law enforcement, and investigators. The order addresses, if the court were to apply strict scrutiny, the order addresses a substantial likelihood that pretrial publicity poses to the integrity of the judicial system, and is tailored to ensure that the rights to a fair trial are upheld. As we briefed in the case of Levine, the alternatives such as sequestration of the jury or changing a venue aren't going to mitigate the impacts of statements, extrajudicial statements in this case, and are unlikely to do so. Thus, the state contends that the order is an appropriate measure of the court to uphold its duty under Shepherd, Nebraska Press Association, and the like to preserve the right to a fair and impartial trial. At a minimum, Mr. Gray's statements that he's not bound by trial publicity rules or 3.6 in this case illustrate why the order of the court is necessary in this matter. And so we would ask that the court uphold the amended non-dissemination order, or at most tailor it to those statements specifically precluded in Rule of Professional Conduct 3.8. And with that, I'll stand for questions.
Thank you, Mr. Redley.
Thank you.
Yeah, do you think that would be helpful to just, and I asked Mr. Gray this same question, would it be helpful to say, okay, you can say these things, but you can't say these things, and be more specific about that?
Your Honor, our initial position is that the total prohibition of extrajudicial statements is the safest and most responsive way in this case to address and preserve the right to a fair and impartial trial.
All right. Can you go back? You mentioned this about the standard particularly applying to the lawyers who are somehow connected with the case.
Yes, Your Honor. In Nebraska Press Association v. Stewart, it's noted that I believe Justice Brennan states that there's no doubt that the court has authority, though it's in a footnote, it's no doubt that the court has authority to regulate the speech of attorneys, witnesses, and other participants in the court process. At this point, the evidence that's been provided is that the family would be potential witnesses in the case. As Mr. Thompson mentioned, we haven't necessarily been able to make a full assessment of that, but undoubtedly they'd be witnesses in any sentencing.
And what about the standard? Strict scrutiny or lower standard?
Your Honor, we would argue that the court should apply the standard in Gentile versus State Bar of Nevada, where the Supreme Court stated that, I don't want to mess this up, so I'm going to look real quick here.
That's fine.
That the speech of lawyers may be regulated under a less demanding standard. So we would argue that so long as the court finds that it has a duty under Shepard to preserve the right to a fair and impartial trial, that the order addresses the substantial likelihood that that negative pretrial publicity would have on that right, then the court would have authority to impose the amended non-dissemination order.
Thank you, Mr. Ramsey.
Thank you.
Mr. Logsdon?
Judge, I think a lot has already been said, and obviously we wrote a lot in the briefing, so I guess I'll just touch on a couple of things. In terms of the argument that the victims' families are not involved in the litigation of this case and therefore don't fall in 3.6, it would be our position that if you have statutory and constitutional rights involving this case, you're involved in the litigation. Regardless of whether or not the prosecution is willing to work closely with you or whatever issue you have there, the reality is if you have literal rights that permit you certain things that are involved in this case, you're involved in litigation, and therefore you would fall within 3.6 just like everyone else. Second, the standard from Gentile is the substantial likelihood of material prejudice. I don't want to get too much into that, Judge. I think that's kind of this afternoon's argument. I think the main thing before the court as far as Mr. Gray and the family is just, do they fall within this, and then the court to decide, what is appropriate. But I would note that given the vast amount of media coverage in this case, and the fact that it seems like no matter what anybody says or does, in one way, shape, or form, it will be twisted into an attack on my client, we also agree that at this point the safest thing to do is for everyone to just not be talking to the media and allow statements to be made here where we all get a chance to speak and the media gets all that information. If they still choose to do what it is they've been doing, then that's on them. But we don't have somebody who's just trying to whip the media into a frenzy and send this case to the firing squad or however it is that you want to put that. So that's our main concern. The only other thing that I wanted to address, and the court addressed this a little bit, the reason we stand silent with grand jury indictments is because there's an old arcane rule that says that if you have a grand jury indictment and you enter a plea, you are accepting the validity of the indictment. I haven't seen a prosecutor try to use that in a long time, but we can avoid any possible claims that somehow we can't challenge anything with the indictment by simply standing silent and having the court enter the plea. So just so that everybody's clear, that's why we do that. Does the court have any questions for me?
I don't think so, but thank you for that additional education.
Thank you, Judge.
Thank you. All right, Mr. Gray, it's your motion, so you can respond to what other counsel expressed. Thank you.
I guess the first thing I would want to address is the prosecution's idea that I haven't allowed our clients to speak with the investigators. You'll realize that the date of the incident, I wasn't retained on this case until close to December 5th, which will be more than 3 weeks after the incident occurred, and they still had made no contact as far as interviewing the victims' families. So somehow that I precluded that in some way is just not true, Your Honor. And as far as scheduling those things, I'll just leave it at that. The second part is everyone is quoting the Gentile case. The Gentile case is exactly like all of the other cases. It says over and over, it has to be a lawyer participating in the judicial proceedings. It has to be a lawyer who represents a defendant involved with the criminal justice system, a lawyer actively participating in trial, a lawyer who's participating before the courts can only be limited if he's participating in front of the courts. None of it applies to me.
It seems like you're in the court right now.
Because you're the one that brought me in here because of the non-dissemination order.
You brought yourself in.
Yeah, well,
you're the one who filed the motion.
I did file the motion because the non-dissemination order is unconstitutional and overly broad.
I'm just trying to clarify what you just said.
Well, this will probably be the only time I'm allowed because I won't have the authority to file any other motions on anything else in this case.
Why would you say that?
Well, because I'm not a party to the case.
Okay. Well, you can still, I mean, the media is not a party of the case either.
Once again, they're not.
Well, the Supreme Court has said they have standing to come into the court and address issues. So.
Yeah, but that's completely separate. They're not parties.
Well, I know it's separate. But
okay, so
I also respect your position in representing the family's victim, the victim's family, and I respect that. And there are some constitutional issues, rights that they have. So I'm not just dismissing that.
And the mere fact that you have a right, I'm absolutely positive that the Idaho legislature and the Constitution, when they gave victims rights, didn't think that was implementing those victims into the trial in some way. Absolutely positive that wasn't the intention of it.
Totally agree with that.
So this idea that if you have rights, then you're involved is just beyond. That being said, Your Honor, nothing precluded the prosecution from contacting my clients well before I was representing them. I had almost 3 weeks to contact them. I think, and don't mark me on this, I think I was retained on December 5th. I think that was the day. I don't have my file in front of me, but don't hold me to it. But I think that was the day. So they had plenty of time to contact my clients and interview them if they were going to be potential witnesses in this case. And since then, every time we have had a meeting, we have initiated that conversation. It hasn't been the prosecution initiating that conversation.
So are you saying since you have been representing your clients that the prosecutor or investigators have not asked for interviews?
I would say this. In the meetings that I have had with the prosecution's office, I have asked, as part of that, whether interviewing my clients might be an issue. Would they like to do that in some way? I've offered that up in some way, and they've never taken us up on it.
Okay.
And maybe a random email here and there that says something and no follow-up whatsoever about anything. So this idea that they are going to be witnesses in this case is just an attempt by the prosecution to shut them up as well as to shut me up. And by the way, people completely forget about this. All of the information that has been disseminated to the public from the get-go was the mayor, Art Betke. Chief Fry had interviews. Bill Thompson had interviews. The coroner had interviews. All of those people had interviews. We didn't. We didn't until we started getting information and started trying to figure out what was going on after they had given interview after interview after interview. That was the purpose of the judge issuing the non-dissemination order, is to quiet them up, not quiet the victims up. They had no control over that investigation from the get-go.
Well, that order was a stipulation between
That's
the state and Mr. Kohberger.
That's the other thing, though, is that the court, after that Zoom meeting, Judge Marshall incorrectly said that was stipulated by all parties. I never stipulated to that. I emailed the
You're not
judge.
a party.
Exactly right. I'm not involved in the
The
case.
stipulation was between the parties.
So
You've correctly stated who the parties are.
we would
I
ask.
agree, but you were suggesting that it was entered to shut down the prosecutor's office.
Why would they
That's
claim?
what you just said.
I do think that part of that was part of the process, is that they understood that their investigation was getting out of hand. Too many people were talking in their investigation, and that's why they stipulated to it. Yes, I do.
Okay, when you say they, you mean the prosecutor's
Yes.
office. Okay.
Yes.
All right.
Do you want me to give you a final, or do you?
Go final.
Okay.
Yeah. You go.
We're not a party to the case. You're very aware of that. I have the right to repeat what my clients say to the media. I also have an independent right that I'm governed by the Idaho Rules of Professional Conduct regarding those individual rights versus my own opinions. But those opinions, I don't firmly believe, would fall under the publicity rule on the Idaho Rules of Professional Conduct because I'm not litigating it or party to the litigation. And the reason those things are in place are because people that have real privied information regarding the prosecution and the defense, which I don't, which my clients don't in any way, it shouldn't apply, Your Honor. Thank you.
Okay. Thank you, Mr. Gray. All right. Well, I'm not going to issue a decision today. I'm going to issue a written decision. There is a lot of briefing, and I heard some very interesting argument today, and I'll get back to work and try to get a decision out as soon as possible. So anything else we need to address before I adjourn? Mr. Thompson?
I don't think so.
Ms. Taylor? Mr. Boston? Anything else?
Your Honor, we thought you'd probably want to issue an order and wait, but I guess we're just wondering if in the meantime the order as it is remains in place.
Yes.
Thank you, Judge.
Yeah. It remains in place until I address it. So with that, we are adjourned. Thank you all. Thank you. We are now on the record. State versus Bryan C. Kohberger, CR 2922-2805. We're in the courtroom. Mr. Kohberger is in the courtroom with his attorneys. Ms. Taylor, Mr. Logston, and I'm sorry, I missed you because you were behind the screen earlier, but also Ms. Masleth is also present. Representing the state is Mr. Thompson and Mr. Rudley, and we're really here for the motion Associated Press et al. I'll call you Non-Party Media Coalition. So if Ms. Olson and Mr. Carone could come up, or I don't know if it's just going to be you, Ms. Olson?
I will be the only one arguing, Mr. Honor.
Okay, well, thank you. So we have a lot of things to sort of sort through, and I know some of your clients are listening on Zoom, and I can't look at all of you while I'm looking out here, but I just wanted to acknowledge that. So I think we probably need to start with the motion to intervene, but let me just tell you my thoughts about that. I think that after reading the Supreme Court's decision, the coalition has standing, and so I think you're entitled to be here and make the argument. But I don't know that I need to grant intervention. But I don't know. What's your view of that?
Well, Your Honor, we think just to have the clearest record possible that the court should grant intervention for this limited purpose. We think that would frankly also be helpful should the situation arise again, since there's simply no rule that sets out whether we can do this or not, which is among the reasons we went the wrong place the first time. So we would ask that the court grant the motion. I don't intend to offer any other argument other than was offered in the briefing, Your Honor.
Okay, let me go to Mr. Rudley or Mr. Thompson.
Your Honor, we don't have an objection to granting the motion to intervene for the limited purpose of challenging the amended non-dissemination order.
Okay, Ms. Taylor?
We don't have an objection either, Judge.
Okay, great. Okay, so I'll grant that request for the limited purpose. The reason I was worried about that is I don't want the media to be really, so to speak, a party that has to be involved in so many things that we're going to be dealing with. So, but I will grant that request for the limited purpose of what we're talking about here.
Thank you, Your Honor. And then if there's just one other housekeeping matter, as the court indicated, some of our clients in the coalition are participating by Zoom. They have been informed and directed that they may not record the proceeding that's occurring by Zoom, but they may report on it after the fact, just like any reporter here in the courtroom, or as if we were with us here in person as our party representatives.
Okay, agreed.
Thank you, Your Honor.
All right. The next issue, though, is this motion for shortened time. I didn't sign that proposed order. Apparently there's an objection, and let me hear from you first about what that might mean for what we're going to do today.
Well, Your Honor, I think given that the hearing has been scheduled today, the court has in essence granted the motion to shorten time unless it were to allow. You want me to slow down? Yeah, sorry about that. I think the court has in essence indicated it's going to grant that motion. We're having the argument on it today. I think the one potential sort of hiccup there or sticking point there might be with respect to the evidence that Mr. Kohberger wants to introduce, to which we do object, given that we became aware of it 3 days ago, and there simply hasn't been enough time to vet the information that they seek to provide. And as we set out in our reply brief, we think it's not appropriate anyway, given that it's the time for them to have introduced evidence in support of the gag order that's in place was in January of this year. So I think that might be the only sort of hiccup with respect to whether the court might end up shortening time or giving them additional time to present that evidence.
Well, I haven't approved the shortened time because I wanted to hear from counsel how they viewed that. I know when I talked to Mr. Carone last time, I was concerned about the short time, and I was really, I don't know, maybe it wasn't very direct, but encouraged that we allowed a little more time because I know there was going to be a lot of briefing. At that time, I think Mr. Logston, said that it's going to be really difficult for us to get things together for an expert, but we'll do the best we can, is what I remember. And so here we are. I was also concerned about the massive amount of briefing that I had to go through very quickly, which I did. And I want to make sure, because this is a very important decision, that everybody has the opportunity to weigh in with what they want to present. So maybe I should go to Mr. Logston and see.
May I offer one other comment
Well,
on that point,
yes, go
please, Your
ahead.
Honor? So, Your Honor, understand, I think we all agree that this is an important matter to address, and that there are significant interests at stake among both the parties and then the interveners. And I think our concern in wanting to move it forward sooner rather than later is that this gag order has been in place since January, since virtually the inception of the case, and it has rendered harm to our clients' interests. And so that's why we wanted to move forward more quickly. And that's why we had offered, we thought, as sort of a interim step, and we were at the hearing this morning and heard your comments to Mr. Logston at the end, but that's why we had sort of offered as a interim step, vacating the gag order pending a more fulsome evidentiary hearing.
By the way, I mean, just so you know, I find that to be a very kind of inaccurate and distasteful name for the order. And I've had trouble about that for a long time, and it's not called that. So I would appreciate not using that term. It's distasteful, and I think it's inaccurate, and I think it's been overstated, just the impact of that order, just to let you know.
Thank you, Your Honor.
Okay. Well, and so you are why don't I go to Mr. Logsdon, and we'll see how we feel about the presentation of the evidence and or expert testimony. Go ahead.
Your Honor, we have two witnesses. We also filed, as I'm sure the court is aware, a motion that we believe the court has the ability to take judicial notice of the media coverage in this case. The media, as we understand it, is essentially objecting to there being a record made at this point. Our stance is this is a live issue, and this will not stop being a live issue so long as our client is in this case. And as the facts, or even if, who knows, you get a United States Supreme Court case could come down a year from now that would change this too. But as things change, everyone has the right to come into this courtroom and say, we'd like to have the non-dissemination order reconsidered, amended in ways that are going to match with what's actually happening. The media has made the point that when this originally was put in place, it was just the parties agreeing that we wanted to make sure that we were doing everything in court and not doing it to the press. And so we didn't, at the time, feel the need to make a big record about what was going on. I think the court mentioned that to some extent what's going on is somewhat obvious. And while we would concur with that, given the media's point and given some of the case law out there, we thought it would be wisest to make a record, at the very least, of the amount of coverage, of the consistency of the coverage, and to some extent of the substance of that coverage. And that's what Ms. Saucier would be talking about from the company TrueScope. And then we also brought in a psychologist, professor of psychology from Eastern Washington University, to basically just kind of talk about why we care. And there are reasons we care that we talked about in the brief that aren't related even to the biases and things like that. We just have overall concerns about, as a country, how do we resolve these cases? Is it in the press or is it in a courtroom? And those are issues that, we don't necessarily need these witnesses to get to. But to the extent that the United States Supreme Court has clearly shown that we do concern ourselves with the effect on jurors, and even the effect on ourselves and our witnesses, that we brought in a social psychologist who can explain what those issues are a little bit better than we just sort of understand them. In terms of, our position is that the court needs these things. We think that they're best to make the record in the case. And I think the court is correct. We thought it would be better to have more time so that everybody could take their best shot. I feel like we did a pretty good job of warning everyone that we were going to be bringing witnesses today. But that, at the same time, like I said, it's a live issue. The court could issue something today. The media could go back, find themselves an expert that they think blows our whole case out of the water, and then come right back to court and say, well, let's do this again. And that doesn't make any sense to me. So I certainly don't have an issue if the media decides what they'd like to do is have additional time to find their own witnesses, or for that matter, to prepare more. We're not going to object to any request to move this hearing.
Thank you, sir. Mr. Rudley, do you want to address that? Maybe you want to come up for the mic. Thank you.
I'll be brief, but the state has no position on the motion to shorten time or hear additional evidence.
Okay, thank you. All right, so Ms. Olson, come on back up. I'll tell you where I am on this. Well, number one, I agree with Mr. Logsdon that this is a moving process, and analyzing this going back to whenever it was imposed is not particularly relevant at this point. A lot of other things have happened. If there was no order in place right now, I could impose it today based upon the evidence that was presented. But there's not really any evidence presented yet, and that's why I asked for potential evidence to support the record. I mean, I think we can probably agree that this is a high profile case. There's a lot of interest. There's a lot of misinformation and disinformation out there in the public, and that's quite concerning. My job is to protect the First Amendment as well as the Sixth Amendment, and there is a balancing in that. I don't think there's any question about any of that. So I'm inclined to allow, the testimony and the evidence. I'm inclined to take judicial notice of the submission of Mr. Kohberger, but I am happy to put this out to give you and your clients an opportunity to respond to that, because I know it's incredibly short notice.
Thank you, Your Honor. It's 3 days notice, but we addressed some of that. We prefer to go forward today, and as Mr. Logsdon just acknowledged, if we feel like there's evidence that we find later, we'll probably just file then a motion to reconsider. And I would just like to address one point, Your Honor. We understand that things evolve, and we're at a different point today on June 9th of 2023 from where the two parties were on first, I think, January the 3rd, and then with the court in chambers with no court reporter taking down anything that happened, where you had to file a redacted memo, and then the amended non-dissemination order that came out of that. We understand we're in a different place, but our point is that the court entered that without any findings of fact that warranted such a non-dissemination order that was what we assert is the order in place now is overbroad and was procedurally deficient. And that's really what our concern is, that there is a First Amendment harm that occurs from a non-dissemination order that is overbroad and where there was simply no opportunity for anyone other than the parties to weigh in behind closed doors with the court. And I was here this morning, and so I heard Mr. Gray say that he disagreed with the record that's been made on that. But I think that's a significant concern, and that the court should be concerned about the procedure that was used initially to enter that non-dissemination order. And that's why we continue to take the position that if the court feels a more fulsome record is needed, that the order in place is simply not justified by what the court did back in January, and it should be vacated pending the development of that more fulsome record, Your Honor.
Well, whether that's accurate or not, I mean, that's why I'm inclined to allow any of the parties and the media to add to the record. I just want to remind everybody this initial order was an agreement. It was a stipulation. It wasn't that Judge Marshall just pulled it out of, air. It was an agreement between the parties. There are only two parties to protect the Sixth Amendment. That was the reason for that, and I would note, because I think this is missed in the discussion, that this was going heavy well before Mr. Kohberger's arrest. So there was a lot of speculation, a lot of criticism, a lot of bad information, and that would trigger for any lawyer for either side to try to protect the integrity of the investigation and the future court process. So just trying to, I do think that this thing has kind of grown a bit out of proportion from where it started and where it is now. Because obviously, if you look at a newspaper or the TV or YouTube or TikTok, or I don't look at any of it, but the media has freely talked about this case. So I think that's really kind of the issue. Like, do we have a responsibility to talk to the lawyers about releasing information that shouldn't be released to the public and allow the media to follow the the First Amendment freely, which they have. What I hope is that they do it responsibly and professionally and accurately. But that's really up to the media. I can only control so much, and you can control only so much of your clients and other media and media that are not traditional. That is really the struggle, and that's why the order was entered originally. Just to give you some background.
Understand, Your Honor. Now I'm going to ask my good friend Bill Thompson if I can have some water. Sorry about that. Your Honor, I think interveners well understand why the parties did what they did in the interests of the parties in this. And interveners well understand that, frankly, for Mr. Thompson, and I've been in Mr. Thompson's position in a capital case.
I know you have, and I know you understand the issues here, and that can collide.
Right, what we know is that the state wants to ensure that its investigation, or the case that its investigators and its prosecutors put together and presented to a grand jury and obtained an indictment, that they can present that case the strongest way possible without having to worry about external events, and certainly external events they can't control. And we know that Mr. Kohberger and his counsel have a tremendous interest here in fighting for his freedom and likely fighting for his life. Because I heard the court earlier today, and I think all of us who have practiced in this area at all know this is likely a death penalty case, but that those are not decisions that have been officially made yet, and that hasn't been put before the court. But that's why Ms. Massoff has been appointed to help represent Mr. Kohberger. She's an excellent attorney. I know her well. She will do a very good job for him. And I know that they have an interest in making sure that when it comes time to pick a jury, if this is a case that ends up going to trial, that they can pick jurors who will fairly and impartially hear the evidence and make a decision based on the things that they hear from the witness stand and not based on what they see on Twitter or the internet or watching the news. That is a fundamental interest of this entire system, which frankly I spent most of my career working in.
Well put. Thank you.
But there are also, Your Honor, this court has tools in addition to non-dissemination orders to make sure that there is the best chance to get a fair and impartial jury when this case is heard, aside from a non-dissemination order, which I'll come back to the parts we find to be overbroad and not having been procedurally accurate. But there's probing voir dire. There are jury questionnaires. There's change of venue. There will be the passage of time, and I think that's where this is a potential, because this is a potential death penalty case, that comes most into play. If the state files a notice of death penalty and it becomes a death penalty case, I would be stunned if this case went to trial on October the 2nd of 2023, because the defense will need to do a mitigation investigation. The defense will need to look at experts from a host of areas who will be able to present evidence about Mr. Kohberger, his life, and why the aggravating factors that would perhaps the state would argue for, why those shouldn't apply, and why the jury should choose a different sentence if it gets to that point after a guilt phase. That takes a substantial period of time, years in many cases. And the passage of time, I understand, we've looked at all of the materials, not in great detail, the materials that Mr. Logsdon submitted from Ms. Saucier and the professor from Eastern Washington, and we understand that there is a lot of publicity now, but I will tell you one of the things that was most surprising in the Duncan case, and I got to say also, when you're doing a big case like that, you're just living that case, you think that's all anybody thinks about. But the most surprising thing to me when we picked the jury in the Duncan case, 3 years after the murders, was that there were people who hadn't even heard about it. I mean, and that's a case where, granted the trial there happened in Boise, that's a case where, we didn't have social media to the same extent yet, but there were cars in Coeur d'Alene driving around with Kill Duncan bumper stickers, and there was, I think it was a donut shop that had on its magnetic reader board, Kill Duncan. That's pretty prejudicial pre-trial publicity, and those things would get picked up in the media. So that passage of time with the probing voir dire, the questionnaire, and the change of venue all did a lot to ensure that there was a fair and impartial jury that was impaneled. And so those tools we would submit are available to this court. Because in addition to the very important interests that Mr. Kohberger has and the very important interests that the state has, and I think as Mr. Rudley acknowledged this morning, the state also has an interest in ensuring there's a fair trial. The media does have an interest in enforcing or fulfilling the dictates of the First Amendment and the free press. And those are equally important principles, at least at the stage of beginning to weigh them, Your Honor. It's through the members of the media and the press that the public learns about these proceedings, that the public is able to understand how the criminal justice system functions, that the public is able to understand how the prosecutors perform, how the defense attorneys perform. That's how they learn about details of the investigation when they're released, either in the courtroom or released through the probable cause affidavit, so they can make their independent judgments about how is our system working, so they can be educated, just as the court did this morning when it started the hearing this morning by pointing out and explaining why someone would come into court and not enter a plea when called upon to do so, and then the court has to enter the plea for them. I mean, those of us who have been in the criminal justice system have seen that before. So it's that kind of educating that can be done by the court, by the people who actually know about the proceedings. I see no reason why after that proceeding, Mr. Thompson might not have been able to, or Mr. Logsdon or Ms. Taylor, been able to answer a question about, wow, that's unusual. Can you really do that? And someone say, well, you know, actually, under the rules of criminal procedure in Idaho or under case law in Idaho, you actually can just not stand silent and not enter a plea, and then the court has to enter not guilty pleas for you. That would have been a very helpful thing to have done. And I think it is educational things like that that can be relayed through the media, that the current non-dissemination order restricts these attorneys from speaking about, or really any attorney, because it's the way it's phrased, any attorney with interest, for a party with interest in the proceeding. That's pretty broad. That's extremely broad. It's not just Mr. Thompson. It's not just Mr. Logsdon, Ms. Taylor, and Ms. Massoff. What does that mean to be a party in interest in the proceeding? I mean, we talked about the motion to intervene, and we wanted to make sure it was a limited purpose so that we suddenly don't become parties with an interest in the proceeding, and then I can't walk outside and talk about what went on in court. So Your Honor, what we're asking for is the court also to look at what does the First Amendment, what role does it play in the court's analysis, and how can it balance those First Amendment rights and use those other tools that are available to it, particularly at this stage of the proceeding, to ensure that the Sixth Amendment right is observed and that the First Amendment right is observed. And we think, Your Honor, in doing that, you have to take a look at the non-dissemination order and apply strict scrutiny analysis. Now, there's lots in the briefing about strict scrutiny analysis. We think the court gets there two different ways. One, because we view this as a prior restraint. In order to have news or publication, you have to not only print the information, but you have to be able to receive it. And if you can't receive it, you can't present it to the public.
Is there law on that?
There is, Your Honor. There is, Your Honor. And it was in our briefing, and I was asked the court to take a look at it's pages 15 and 19. It's not in one of the big three Supreme Court cases we've all talked about. It comes primarily from the Young case, but that's where that comes from. There's nothing in those three Supreme Court cases that says that you don't apply strict scrutiny when it's a restraint on someone other than the media, other than perhaps the Gentile case where it says they're talking about the lawyers, and it says that, but you still have to be able to show that it's prejudicial publicity. And then you have to have a narrowly tailored tool that's designed to restrict it. And Your Honor, regardless of what the test is, there has to be prejudicial pretrial publicity. Publicity that could prejudice Mr. Kohberger's right to a fair trial. So publicity generally, and I think this is where Mr. Logsdon submits Ms. Saucier's information, there's no reason to think that publicity generally is prejudicial. It's a publicity about the case, and it allows people to hear about the case. But some of the things people are hearing about the case may not be all that flattering for the state. It may be not prejudicial to Mr. Kohberger. It may suggest things about the investigation and how it was done. So publicity in and of itself is not prejudicial. And that's why I think when we get to what is out there, that courts typically rely on first blush is Idaho Rule of Professional Conduct 3.6. And those line items of what attorneys for parties in the litigation may not comment on. Those are rules that are vetted. I mean, they're the same as the ABA rules or the basic rules that every lawyer has to follow about, you can't, if you're a prosecutor, you don't get to walk out of the courtroom and say, well, in this case, we've got the guy because X, Y, Z, whatever. And if you're, you just can't do that under the rules of professional conduct. And there's no reason to think any of these lawyers, who all are fine officers of the court, are going to ignore their obligations under Rule 3.6. I understand their desire and their interest in having something more prophylactic so that they can operate in the way that doesn't, so they frankly just don't have to worry about that. But it's our position that the First Amendment requires more and much more and requires a narrow tailoring, and that when you have a non-dissemination order that starts out and says all extrajudicial judicial statements you cannot be made. I mean, I
can fix that, can't I?
Sure.
I mean, so if I just and I kind of raised this this morning too, that if I am more specific about who is touched by this order and what can people say and what can't they say, then that would help your concerns, wouldn't it?
It would, Your Honor.
And I'm acknowledging this because your motion is to completely vacate it.
Absolutely, Your Honor. And then the reason it's to completely vacate it is because we don't feel it's narrowly tailored. And so a overbroad, non-narrowly tailored order that, and I respect what the court said about procedurally how it came into place. That might be one where you just have to agree to disagree. But it's our position that such an order should not be in place. If the court then wants to enter another order, then it has to do something that is designed to address or limit substantially prejudicial material, prejudicial pretrial publicity, and make sure that it is narrowly tailored. And that's why I think Rule 3.6 continues to sort of be the guiding star on that, because it lists the things that tend to be most prejudicial. And so certainly if the court takes a different approach, we will look at that, and we would certainly hope that the current order we think is overbroad and procedurally deficient, and we recognize the court's ability to hear all that it's going to hear, and if it chooses to craft something and still thinks one is appropriate, obviously we will take a look at that and see whether we think it still suffers from the same deficiencies as the current amended non-dissemination order. I would also say, Your Honor, because I heard your questions to Mr. Gray and the rest this morning.
I'm glad you're here. Yeah. So you might want to address.
And so this would be our position with the concept generally, setting aside our position that it shouldn't be there at all. But I think that limited to Rule 3.6 is palatable, at least because that's the obligation that the lawyers on both sides already have. I think it would be very difficult to then have a list of things that you could say. You could say this, but you can't say this, because then it would be impossible to think of every possible statement that could be made. But if there's clear direction on the statements that cannot be made, and they are the things that are set out expressly in Rule 3.6, that gives very clear direction, is consistent with the Idaho Rules of Professional Conduct, and would leave sort of no guessing for the people who do want to provide adequate guidance and information. And then we would also ask the court not to do something about the language that says attorneys for all interested parties. I think, frankly, that's sort of just inherently vague as to what that means. And when there are very specific parties here before the court, I think the court could narrow that a tremendous amount. And I heard that dialogue this morning with Mr. Gray regarding witnesses. And I will say, Your Honor, that's obviously not, I think our preference would be witnesses not be included. But when one looks at, for example, the family member witnesses and the fact that they may be called, certainly if there is a sentencing phase of this, and they may be called by the prosecution to show victim impact, to provide that information. There's very detailed law on what you can have a family member say in a capital sentencing hearing. And it's usually the kind of thing that is, you know, my child was a great kid. They were the light of everybody's life. Here's the video of them dancing at their, you know, 5th grade Christmas program, and that sort of thing. It's not details about the case. So for those reasons, we would think something that restricts witnesses who are not going to be fact witnesses in the guilt phase, we think that would certainly be overbroad as well.
Okay. So let's go back to, because we kind of, I mean, that was great. Thank you. I appreciate everything that you said. That, I mean, I am going to grant the request to present the evidence, or I don't know, just the submissions, we'll just say, and take judicial notice of that and allow for the testimony. But you will have an opportunity to come back if you choose to do that.
Well, I'll probably do some cross-examination today. It probably won't be as tight as it would be as if I had an opportunity. And just
absolutely, you have the opportunity to do that.
And I think, Your Honor, just to be clear, you know, we made some arguments in our reply brief about why these individuals are not the experts. They would never qualify as experts under the federal rules of criminal or civil procedure based on the things that they list in their CVs and their prior work. I mean, if they're only offering Ms. Saucier to say there's lots of publicity about this case, I don't think anyone's going to disagree with this. But I would point the court to now, and then I don't know if Mr. Logston will want to ask her about this on direct, but in her report, and she's got some little tables, and it's not, the version we have is not paginated, but there are two tables, and one says authority figures share of voice, and then non-authority figures share of voice. And on authority figures share of voice, one of the people that's listed on there is David Nye. I mean, I don't know why David Nye is someone that they're saying is an authority figure on all of this. David Nye is a federal district court judge in Idaho, as the court knows. Maybe they meant Jeff Nye, who I think is assisting Mr. Thompson, but that's, I anticipate, as an error in the report. And then if you look at the next page, at non-authority figures share of voice, and then share of voice media coverage, the person with the greatest stories in the data set is Rebecca Boone, who's an AP reporter, and then the same thing of share of voice media coverage. And of course, the AP stories run all over the country, and they get shared in different publications. So I suspect that might be one of the things Ms. Saucier will say about that. But the definition she uses in her key terms defined is authority figures are experts who are currently working on the case. That's too much caffeine this morning. Authority figures are experts who are currently working on the case. Well, David Nye is not currently working on the case. And then non-authority figures are, her definition, experts who currently work in or formerly worked in the field of law enforcement, police or FBI, law, such as lawyers or other court-related personnel, but who are not working on this case. Rebecca Boone isn't any of those things, and she's the primary person they put forward in that, Your Honor. So if the court wants to consider that, I mean, I think just right off the bat, there are a number of things that make it inherently unreliable.
Let me just be candid. I mean, I'm not going to put a lot of weight on that because, as you said, starting out is, I mean, there's no question about how much information has been poured out about this case. I'm allowing Mr. Kohberger to make a record, okay, because that's something that has been raised by you and your clients, that there's not a record to support this, to justify it. So I feel an obligation to let everybody weigh in with what they think justifies an order. And I don't disagree with what you're saying about the narrowing or being more specific. one of the questions I heard you talk about prophylactic, and I think that's an interesting question when you talk about other options to deal with a fair trial. Going to another venue, for example, or sequencing.
Sequestering.
Yes, thank you. That is complicated. It's expensive. It's time-consuming. And so if we can be prophylactic about it by limiting, okay, what lawyers who have a different standard, okay, lawyers who are actually directly involved in the case have more credence, okay, in the public. And that's a reason to restrict that. And that's why I don't like the term gag order, because nobody's really gagging about it, okay? These are lawyers who already are restrained by ethics and professionalism. So that's really what we're talking about, to kind of do what we can, even though I don't even think the media can really control all the information that's going out there every minute, right at this moment. And so this is not the same world as it was 10 years ago or 5 years ago. And it is troubling for the media, the ethical, hardworking media, and the information that's swirling around in the world. I don't know what the answer is, but it's a serious threat to a fair trial and the credibility of media. That's just a side speech. I apologize.
And I'm not sure that anyone would disagree with that. I mean, we live in an age where finding out what the facts are is more and more difficult with every day. And both the participants in this criminal justice system, the court, lawyers for any party, and the members of the media, we all participate in systems that are designed to be fact-based and that are designed, when they function well, to get the information out that's truthful and accurate and through a process that is most appropriate. And I don't think anyone would disagree with you, Your Honor, that right now that there are certain, because everyone can have a blog or be on Twitter or be on, I mean, there are so many social media channels out there now that for a person of my age does not hardly know any of them. But those are all certainly out there. And no order from this court, respectfully, Your Honor, is going to reduce any of that. But when there's an order from this court that limits the ability for people who have actual facts and good information to provide statements about things like the court did this morning that can educate people about the process. Certainly, no one's expecting that either Mr. Thompson or Ms. Taylor or Mr. Logsdon or Ms. Massoth are going to, if the court lists the non-dissemination order, are going to run out and tell you everything they know about this case. They're not. And so I think, Your Honor, if the court, and it sounds to me like the court is inclined to have some sort of second amended non-dissemination order, I would urge you to make it as narrow as possible so that the actual facts can be relayed to the members of the media. And I think when you look at who the media coalition is that came before this court, I mean, this is a group of Idaho-based, some Washington state-based. It's hard to be in this part of the state of Idaho and not be completely familiar with Washington. And then some national outlets that continue to have an outstanding reputation. And what they want is for their reporters to be able to obtain accurate information and information that is of the kind that is not, they understand the things that probably the lawyers are not going to tell them, but information that might help the public better understand all of this. Because the other thing that is just so, is the background of all of this, is these are tragic events that affected this community, the entire state of Idaho. I mean, there's probably nobody who doesn't know, no one I know who doesn't know someone in Moscow who was affected by this tragedy. And I think as part of that, then there are people who really have an appetite for accurate information about this case. And what we would ask this court is not to have any sort of non-dissemination order that restricts the public's ability to understand these proceedings and to get accurate information.
Okay, so thank you. What I would like to see, maybe we all like to see, is the media actually doing more complete analysis of process, okay, and explain to the public why we do what we have to do in protecting a fair trial. I haven't seen any of that. Now, I'm not out there following the news carefully. I think our local press has been really fair and pretty balanced, and I appreciate that they are talking about some of the details and explaining kind of why things are happening. That would be nice to see more of that instead of the sensationalizing that we are seeing in the national media. So, and by the way, I haven't made a decision at this point. I mean, when I ask questions like this, I'm testing my thoughts about where we might end up. So I don't know if you want to address anything else about the evidence or further your argument. I kind of interrupted you there. But
No, Your Honor, I think we've made it all the way through the things that I had hoped and planned to tell the court about, the standard it should use to analyze this, the reasons it should vacate the current non-dissemination order, and then our thoughts on if the court is inclined to look at a different measure to ensure a fair trial, that it use some of those tools that are available to it other than a non-dissemination order, particularly when realistically the trial in this case is probably at least 2 years out because of all the things that the defense will have to do if this is a capital case, and they'll do it well. Yeah. And you don't do that in I'm bad at math, 4 months.
Well, that remains to be seen. But
I understand.
I understand what you're saying
Yeah.
too. So, and you're sticking to strict scrutiny.
Yes, Your Honor. I think for 2 reasons, Your Honor. The first is because we view it as a prior restraint, and because in order to both, it has to be, in order to report information, you have to be able to gather information. And I would direct the court to page 15 of our brief for that. And then separately, Your Honor, when the court is balancing 2 competing constitutional rights, we would submit that the court has to apply strict scrutiny. I think that's on page 19 of our brief, Your Honor. And then finally, I would say, Mr. Logsdon submitted a bunch of materials to the court. If the court's inclination is to sort of give them the weight they deserve, I'm not sure I'll spend a lot more time on it, other than I wanted to point out those 2 quick errors that I was able to find in Ms. Saucier's tables. But we submitted declarations from reporters who I think their experiences illustrate sort of what happens when you have an overbroad non-dissemination order like this, where people who really are not involved in the proceedings, people who are being asked about topics that aren't really directly related to the facts of the case, they're citing the non-dissemination order for reasons they can't talk to the media. And that just, I think, sort of reinforces why you're going to get the things that we see on social media and the internet, and the things that the court has expressed concern about.
Well, let's just, one of the problems there is, I think that a lot of the media were suggesting that the order was much broader than it actually was. And so maybe people responded to that. The other option would be that they were just using it as an excuse because they didn't want to talk to a reporter. And that's their right?
Absolutely, Your Honor. But that's what they said to the reporters, and that's what those reporters said in their declarations to the court. So
let's just say, just for the sake of discussion, that if I just lifted this order, what are you after that the media doesn't already have? You want to be able to talk to the prosecutor You want to talk to the defense attorney? I mean, how far does that go? You know that you just can't open their files.
Absolutely. It would just allow them, it would allow Mr. Logsdon, if he wanted to respond to a question in the manner that he did in court today about why Mr. Kohberger stood silent instead of entering pleas. It would allow him to respond to that. It might help them describe what's going on in the court. Something happened in court today, and can you explain what that term means? Things like that. It happens pretty routinely in lots of other criminal cases. It might also then take away these law enforcement agencies in other locations who are reluctant to respond to public records requests because they're concerned about running afoul of a non-dissemination order issued in another state. There would simply be better sources of information available to reporters. But again, everyone would still have the opportunity to say, I choose not to speak with you. But they wouldn't be prohibited from doing so by the court.
Okay. Thank you.
Thank you, Your Honor.
Okay, good job. I appreciate it. Let me go to Mr. Rudley or Mr. Thompson.
Oh, Your Honor, the parties discussed Mr. Logsdon making his presentation first since it's more substantial.
Okay, Mr. Logsdon.
Well, we do things a little differently, I guess, up north, because I'm used to putting the evidence on and then we argue, and now I'm a little thrown because we've had argument.
You can go ahead, and Ms. Olson can come in and question if she wants.
Okay.
We didn't know until we were kind of halfway through the argument about what we were going to do with that.
I understand, Judge.
Thank you.
So I think I'd like to start by moving the court to take judicial notice of the press materials that we provided and essentially have the court acknowledge that it has the power to take judicial notice of the press coverage in this case.
Okay, I'll do so over objection.
Thank you, Judge. And then we would like to call Ms. Jean Saucier. She is available via Zoom.
Your Honor, it may have been
yes,
suggested.
come on up.
May I come back up?
Yes, come on up so we can hear you.
All right.
Thank you, Ms. Olson.
And may Mr. Colon come up as well?
Sure.
All right.
Come on up, Mr. Carone. Thank you. Okay, so there's a lot of people here. There she is. Saucier, is that right?
Yes.
Ms. Saucier, could you please raise your right hand?
Do you solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. Thank you, ma'am. Could you please state your name and spell your last for the court reporter?
Yes, Your Honor. Jean Saucier, S-Jean-Saucier.
All right. Thank you, ma'am. Mr. Logsdon?
Ms. Saucier, how are you employed?
I'm employed with a company based in Nebraska, headquartered in Nebraska, called TrueScope.
And what is it that that company does?
TrueScope is a global media monitoring and measurement company. We provide media intelligence data.
And how long has TrueScope been doing that?
TrueScope has been doing this for 3 years. The company that I worked for previously was acquired by TrueScope. That company was Universal Information Services, and that company had been performing media monitoring and intelligence services for over 50 years.
What does that mean, media monitoring and intelligence services?
What that means is that we, companies such as ours, provide data to corporations, organizations, both in the profit and nonprofit world, to show what's being written about or talked about or communicated about their company or other types of maybe projects or things that they're working on in the world. And media companies pull in that data to show return on investment for maybe a for-profit company or other key messages that are being written about or talked about.
And approximately how many clients rely on you for that service right now?
Currently, we have about 270 clients throughout the world.
And when it comes to how are you able to collect this data? Is it like an algorithm? Like, how does that work?
So it is, there's a lot of technology behind it, but sort of broadly speaking, the way that our system works is it will ingest content. We have licensed data sources that provide to us content via API. That content is pulled in from all media types, from broadcast, print, social, web, and that is pulled in via API. And then where that content is housed and stored for the front end of a web platform where our clients can review that data, filter that data, chart that data, and that's how they can see what those messages are and where they're sort of have a gauge on the important content of what they need to see.
And what's your role in this?
My role at TrueScope is I've been with the company TrueScope, previously Universal Information Services, for almost 8 years. I'm Senior Vice President of Client Success.
And in that position, what kind of knowledge do you have of the way in which the company performs its task of collecting this information?
So I am very involved in the customer support, training, onboarding, client demoing. Demos, something that we do to show what the platform looks like, what it can do, the capabilities, the features, functionality. I also lead the team that provide and produce curated reports. We do that for media insight, and we do that for executive daily news briefing.
And what's your understanding of how accurate the data that you gather and produce is?
Our data is extremely accurate and authentic. We are not, our clients rely on us and have relied on us for a long period of time to have data that's coming from licensed sources, the top data sources that are able to provide that data. And I'm not a developer, so I can't speak to the technical details of the ingestion, but our data and the algorithms that we use to process that data is extremely accurate.
Is your company a member of any associations? Is there anybody that makes sure that you're following whatever kind of rules you have to abide by to make sure that you're providing accurate data?
Absolutely. We are a member of the International Association of Measurement and Evaluation. That's the leading global, it's called AMEC, and that's the global organization that oversees evaluation and measurement. We also are members of CBEP, which is the World Media Intelligence Conference. The president of our North American company, Todd Murphy, is an executive, he's on the executive board, and he is a VP of CBEP at Congress.
Do you know if you have any kind of margin of error for what you guys produce?
The margin of error for media monitoring is really very low, and that is any margin of error would be as a result of what was published. If something was published inaccurately, we would have that same margin of error.
So you don't get wrong whether or not something was published?
I'm sorry, can you repeat that?
This is the fact that something was published and is related to your client's request. You're 100% certain that it's always going to be a story related to that? Yes,
based on keywords and parameters that we utilize from the client to pull that data.
I see. So we contacted you in this case, is that right?
Yes.
And what is it that we asked you to do?
You asked us to begin to monitor content for all media types about this case.
Yeah, and how did we set that up?
So we set up the workspace or the platform, as we call it, and the report. We do that internally with our team of experts. But in order to set up the terms, the messages, and the names for tracking, you provided that to us.
And as a result of that, did you create some, I don't know what we're going to call them, graphs for the court today?
Yes, we did.
And is that what we had labeled as Exhibit A?
Yes, that's correct.
And is everything in that true and accurate as to what it is that you created using the software that your company runs?
Yes, it is.
Your Honor, move to admit Exhibit A.
Any objection?
For purposes of this hearing, no, Your Honor, but I would preserve my objections regarding whether this is appropriate expert information. I'll address some of that on cross.
Okay, thank you. Mr. Radley?
No objection.
Okay, anything to respond to that objection?
I guess I'll wait and hear what the rest of that objection turns into, Judge.
Okay, well, I'll accept that, but I'll admit this for purposes now, the limited purpose that Ms. Olson just described.
So, Ms. Saucier, do you have the exhibit on your screen?
I do.
And is it the same exhibit that was attached to the PDF file of the filing that we did in this case?
Yes.
Can you do a share screen of the first page of that?
Yes.
So this is the first page that we see after the big Exhibit A that I put on the front of it. Is that correct?
That's correct.
And what is it that we see in this, I guess we call this slide?
This is a report that we exported from the TrueScope platform on June 6th, containing data from November 13th, 22 through June 6th, 23. It contains volume, potential impressions, unique authors, metrics over time, key phrases in that particular data set, top people mentioned in that data set, organizations mentioned in that data set, and location, and media type.
Can you go to the next page?
Yes.
And what do we see here?
This is an aggregate total of volume, potential impressions, and unique authors between the dates of November 13th of 2022 to the 6th of June 2023.
What does total volume mean?
I'm sorry, can you repeat that? It's a little muffled.
What does total volume mean?
Total volume is an aggregate total of the volume of media coverage for that time period.
So that's every...
That's every media for every type that we're tracking.
And then what are potential impressions?
Potential impression is a metric that shows it takes into consideration circulation to show what the readership might be, what the potential total readership might be.
So if that number right there is 2.1 billion, you're telling us that potentially there have been 2.1 billion readings.
Correct.
And then I think we can partly guess, but unique authors, I take it as just how many different people have written about this.
Correct.
Can we go on to the next page, please?
Yes.
And what do we see here?
This is metrics over time between the 13th of November and the 6th of June of 2023, November of 2022, excuse me, to the 6th of June of 2023. And this is a chart looking at volume, potential impressions, and social engagement. Social engagement, it refers to how widespread social shares are. So engagement, shares, likes, etc.
So based on this, we can see that, I mean, it looks like there's never a time when there aren't publications of some kind coming out about this case.
That's correct.
Why does the potential impressions bump go way up back in January and has completely fallen off even as the volume and social engagement go up?
The potential impressions typically is going to rise if there has been some significant event on a particular day or in a particular time period.
Okay, but why is it precipitously dropped even as all these stories are coming out? Are you frozen?
No, I'm thinking. I'm not sure that I have a clear answer for that.
So would that tell us that the stuff that's coming out as the volume of stories increases, that there are fewer people looking at whatever kinds of stories those are?
Objection leading.
Overruled.
I'm sorry, Your Honor, can you repeat that?
Go ahead, Mr. Loxton.
You can answer the question. The question was...
Okay.
She wanted you to repeat it.
The question was, would this tell us that even though there's a lot of stories coming out, for example, in May, the actual circulation of those stories is pretty low?
Yes, that would be accurate.
Okay. Can we go to the next page? What is this?
This is what we call a word cloud, and it is a chart that we have as part of the TrueScope system that shows what some of the key phrases are in any data set with any particular date range. In this case, November 13th through the November 13th, 2022 through June 6th, 2023. And what it's showing is what some of the keywords, key phrases that are organically pulled into the data set based on the parameters we set up. the larger wording means that there are more, the volume is higher for the larger the words are.
Can you go to the next page?
Yeah.
Is this one, is there anything we need to know about this? It seems self-explanatory.
I think it is fairly explanatory. Again, it's top people mentioned in the data set for that same time period of November 13th through June 6th. And again, this is looking at all media types.
And next page.
This is top organizations, same rules apply with within that time period with the parameters that we have set up. These are the top organizations or companies that were listed.
And the next page.
And same thing here, top locations in the data set between the 13th of November of 22 to the 6th of June 2023.
And the next page.
And this is a media type breakdown in a pie chart format between the 13th of November 2022 to the 6th of June 2023. And it's just showing the percentages of content within each media type.
And the next page. All right, well, so this is the one that everybody wants to talk about. Can you give us an understanding of what it is that we're looking at here?
Yes, this is a chart that our Media Insights team created based on the content that we exported from the TrueScope platform into a CD, Excel file, PDF, and then charted it on this graph. And it is showing the content for each authority figure and what we call share of voice. So that's volume and impressions, and that's showing the time period of 11/13 of 22 through 4 of 23.
Can you explain the share of voice a little bit better?
Sure.
How do you know? I mean, it makes it sound like, if, for example, we're talking about the Moscow police, they get to talk, I guess, what, the most? I mean, what does that tell us?
Sure. So what this is showing, the Moscow police, let me pull this up a little bit more. So the Moscow police have the highest volume in the data set, and then we put that number in that data set, and the volume is in blue and the potential reach is in the darker. It's purple, but it looks more blue here. So the Moscow police have the highest volume in the data set. That meant that they were featured or quoted or somehow listed in 24,585 stories. With that, they have the large potential reach, which is potential impression. And you can see over to the right that we have potential reach listed on the right-hand column side. And so that is at almost 62 billion impressions. So that means that and I'm not, I don't know that you want me to interpret the data, but this is an aggregate look at how far the potential of the messaging from each of these names and organizations went through the data set.
And to the extent that you have listed David Nye instead of Jeff Nye, is that our bad?
We did not change any of the names that you provided.
Okay, next page, please. So this is essentially the same thing. Is that right?
Correct. That's correct.
And in terms of the concept of what's authority versus non-authority, where did that come from?
Authority versus non-authority came from your office.
I missed what she said. Came from?
Me, Judge.
Oh, you. Okay, thank you.
Yes.
Next page, Judge. Sorry, Ms. Saucier. And this is just another slide comparing Mr. Gray. Yeah.
Correct. So this slide, your office asked us to prepare for these particular names to do a share voice chart showing what each of them, where each of them fell in the data set and on the chart.
Is that the last page? Are we done yet?
And we have a
Key terms of time. Okay. All right. Well, I don't believe I have any other questions for you, but you may get some from some of the other attorneys. Thank you.
All right. Thank you.
Thank you, Mr. Logston.
Your Honor, I have a hard copy of Exhibit A. Does the court want that to place in the record?
Yes, please. That'll be admitted. Defendants A. Mr. Rudley, do you want to weigh in at all before Ms.
We have no questions, Your Honor.
Okay, Ms. Olson.
Thank you, Your Honor.
Good afternoon, Ms. Saucier. My name is Wendy Olson. I represent the intervener media in this
Good
case.
afternoon.
Ms. Saucier, where are you coming to us from?
Do you mean my location?
Yes.
I'm in Chicago, Illinois.
Okay. And when did the Kootenai County Public Defender's Office hire you for the work that you've done in this case?
The first day of our agreement was February 15th, 2023.
So February the 15th of 2023?
That's correct.
Yeah. And in all the data that you've shown here in court and are in Exhibit A, I know that starts of November 13th of 2022 and goes to June 4th of 2023. Why did you start with November the 13th of 2022?
Because that is the date that our client asked us to begin searching, and we were able to pull in historical content previous to the agreement or the data we started searching for most media type.
And I apologize, Ms. Saucier, but the copy of your report that I have, that's Exhibit A, doesn't have any page numbers that are in it. But if you could look at, let's just pick the one that is, metrics. Well, let's start with the first one. I guess it's page 2 of Exhibit A. And if you wouldn't mind putting that back up, ma'am, so we could see it here in court.
Sure.
Yeah, right there.
You said page 2?
Yep. No, sorry, the one above that, the first thing is total volume, 46K. All right, and this one, is there any way that we can tell from this slide how much of that volume occurred from November the 13th of 2022 to December 30th of 2022?
Not from this slide, no.
And is there any way we can tell from this slide how much of that total volume occurred after January the 13th of 2023?
Not from this slide, no.
And ma'am, would that be the case for all of those slides, that from looking at anything in Exhibit A, the only thing it tells us is what happened over that large period of time, and it's not broken down by date set, correct?
From this slide, it is not broken down.
Yeah, and so if we go to the one that says, I apologize. And for the one that says authority figures share of voice, and again, I don't have the pages, so I apologize. And that one there that says, Moscow police and is just under 25,000, you can't tell us how many of those were before December 30th of 2022? How many were after that? How many were before January the 13th, and how many were after that? Is that correct?
Not from this slide, though.
And Ms. Saucier, when Mr. Logsdon asked you the question about David Nye, I assume you don't know who David Nye is, correct?
If you mean personally, no, I do not.
Well, at all. Do you know who he is have you learned who he is in the course of all of this?
I did not spend a lot of time looking up or researching any of the authority figures or the non-authority figures.
You just took the information that Mr. Logsdon provided to you, is that right?
That's correct.
Right. And so you have no idea of knowing whether, in fact, the person is an appropriate person to include in the data set as an authority figure, or if they're not. Is that fair to say?
We utilized the names that we were given from our client based on their knowledge and expertise.
Okay. And do you have, as some of the information that you prepared, is there an addendum or anywhere where we can look in order to evaluate your information at that list of names that were provided to you by Mr. Logsdon?
I'm not sure that I would have the authority to provide that to you.
Okay, well, that's data that you used in your analysis, right?
That's correct.
Okay. And with respect to this data set, what do you mean by that, the data set? What is that?
The data set is the volume of coverage that is in our system based on the dates that we have filtered for.
Yeah. Well,
so in this case, for these slides, we filtered 11/13/22 through the date that we created these each particular chart. In this case, June 4th, 23, to get the most accurate data set, most up-to-date data set.
all right, but what I'm asking is, what's in that data set? Is it a whole bunch of, is it 20 different media sources that you run search terms against, and then somewhere downloaded is all of the stories or whatever you want to call them that come back when you run that set?
So in the platform for the workspace that we have set up for our clients, all of the content that we have ingested since we started working with that client, and this is the case for any client, any coverage that has come in through our system that has been tagged, for lack of a better word to just try to explain it, that has been pulled into our system is in a platform, a workspace, a web-based workspace, and we have access to pull all of that data or to filter based on a name or organization or any number of many other filtering options.
Okay, I'm still, I guess maybe I'm just not understanding how you get the data set. So is it, let's say on November the 13th of 2022, somebody ran a story about a 911 call made to the Moscow Police Department, and it runs and it's an Associated Press story, so it runs somewhere initially, and then it gets picked up by a bunch of other people. How does that get captured in this data set that you're talking about?
So from how that gets captured into this data set is through the front end of our system. That data resides and is housed and stored. And so let's say it was an AT story that is in, that then to fill the parameters that we're searching for, that story will be in the workspace, in the platform, and we're able to pull that based on filtering parameters. Let me try to explain it a little bit more clearly.
And are you looking at something, ma'am?
Pardon me?
Are you looking at something as you're trying to provide an additional explanation of what this is?
No, I'm not.
Okay.
But we use the front end of our platform, which houses the data that's pulled in from the back end of the platform, and that data is pulled in from our data sources, ingested in a number of different ways, primarily API feeds.
And so is the data like a news story about that they've given you one of the terms on? Okay.
Yes, so it's the published content.
Okay.
I'm sorry, maybe I was clear.
All right.
It's the published content.
So the actual story would be there, is that right?
That's correct.
Right.
That's correct.
And for then when the actual story is in there, to put these charts together, you went through and just basically counted in how many of those stories certain terms appeared. Is that right?
That's correct.
Okay, so there's no effort to like qualitatively examine what the story has, right? It's simply a counting exercise about how many times certain terms appear in the various media sources that get ingested into your platform. Is that right?
Yes. In this case, and many of the cases for our clients, we are looking at quantitative total versus qualitative.
Yeah. And a lot of times, it's because you want to see what sort of phrases your clients want to see, what sort of phrases are catching on with the media, right?
There could be any number of reasons for doing that.
Yeah, including that, right? You know, if you have a new like slogan, someone might hire you to see, hey, is our slogan being picked up on Twitter or those sorts of things? Is that right?
That's right.
Okay, and that's sort of where that idea comes around for that word. I forgot what you called that. The word thing where some of the words were bigger than others.
Correct.
Yeah. And so, Ms. Well, I have a few more questions for you, Ms. Saucier, although probably everyone else in the courtroom went sure. So with respect to these charts we're on now, this authority figures share of voices, the next one is a non-authority figure share of voice, correct?
Correct.
And you said that's a term that came from the Kootenai County Public Defender's Office, right?
That's correct.
Yeah. And so that's not a term that you ordinarily use in the work that you do through TrueScope?
That's correct.
Okay. And it says and I read your definition, and it must be the one that was provided to you that's on, it's not on that page, but it's two further, and it says non-authority figures are experts who currently work in or formerly worked in the field of law enforcement, police or FBI law, such as lawyers or other court-related personnel, but who are not working on this case, correct?
That's my understanding.
Yeah, well, that's information that was provided to you, right?
Correct.
And so you didn't like use really any expertise there. You just used the definition they gave you and counted some stories that had these names in them. Is that right?
I'm not quite sure how to answer that question.
Okay. Well, let's back up to the one that says non-authority figures share of voice. Now, the one above that. Right there, yeah. Right there. And the person that has the highest number there, and I guess there's this other line that talks about potential impressions. I'll come to that in a minute. But this line that says Rebecca Boone, AP reporter, I take it that's information that was provided to you by the Kootenai County Public Defender's Office as well. Is that right?
That's correct.
Yeah. Do you know? I mean,
However,
do you know who Rebecca? Go ahead, ma'am.
As we're looking at media content, our platform pulls in the content and also takes us to that original published story, so we are able to see if something is written by a reporter, such as was the case here for Rebecca Boone.
Okay, but my point. So she's an AP reporter. But she's not, as far as you know, someone who currently works in or formerly worked in the field of law enforcement, correct?
I do not know anything about her background.
All right. Well, would you agree with me that if she's never currently or formerly worked in the field of law enforcement, law, and those things previously, but is not working on this case, she would not fit the definition of non-authority figures that you used in your analysis?
That's correct.
All right. And did you do any sort of quality control on this, Ms. Saucier, to determine whether, in fact, the individuals listed here were persons who currently work in or formerly worked in the field of law enforcement?
I did not do background research on the names that we were given from our client, nor did I do background research on names that appeared organically in the data set, which many of these on this chart did.
Yeah. And so you didn't check whether or not any of these people actually were currently or formerly working in law enforcement, right?
I did not do a deep dive into anyone's background.
All right, including Ms. Boone's.
That's correct.
And Ms. Saucier, would it be fair to say that there's a number of journalists here in the courtroom today, and that if they all write a story about this and talk about your presentation and indicate that you had things in your chart that referred to Ms. Boone, and that I asked you questions about Ms. Boone, into your data set are going to pop all of those other stories or stories that refer to Rebecca Boone. Is that right?
Can you repeat that question?
Sure, it was kind of long, so bad question. So, Ms. Saucier, there are a number of journalists here in the courtroom this afternoon, and if they all write stories about this hearing and mention that there were slides in your presentation that referred to Rebecca Boone, and you were asked questions about Rebecca Boone, those stories they write that refer to Rebecca Boone would then pop up in your data collection that your firm is doing for the Kootenai County Public Defender's Office, correct?
Stories may pop up, but based on volume, they wouldn't necessarily have a very large share of voice if we were to be charting or looking at them from that app.
My question was just whether they would pop up in your data set.
They would pop up in the data set if it was about the case,
right.
yes.
Right. And you're familiar with the Associated Press, I take it, Ms. Saucier?
Yes.
And you know how they work. A reporter for the Associated Press may write a story in Moscow, Idaho, and once they put it up on the wire, that could get picked up in all sorts of exciting places like Des Moines, Iowa, where I went to college, or let's say Crete, Nebraska, right outside of Lincoln, or any of those places, right?
That's correct.
Okay. And they might run, because they run in a different publication, they're going to be counted as a different story. Is that right? In your data set?
Correct.
Okay. Ms. Saucier, I have a question about, I think it's on 2 pages later. It's the second page of your Exhibit B. And is that in evidence?
B is not.
All right.
We
Well,
can
then,
put it in evidence.
Yeah. Well, it's submitted to the court. So I don't mind offering Exhibit B. Do you have that with you, Ms. Saucier?
Okay.
I would move to admit B.
Okay, no objection?
No, I thought I was offering it, but that's all right.
You are. Well, okay.
Anybody who wants to offer can offer it.
All right. It's a dual offer. I'll accept that, no objection.
We all
Thank
love
you.
Exhibit B. And so I apologize, Ms. Saucier, and I know it's late in the day, but your document was upside down. So is there any way you can turn that so? Oh, there we go. All right. So if we go down to, on the second page of the text of Exhibit B, it says impressions. And do you recall discussing that term when Mr. Logsdon was asking you questions?
Yes.
And so you say here that circulation impressions should be considered as opportunities to see a story, correct?
That's correct.
And not the actual number of individuals who read or viewed a story, correct?
Yes.
And so there's no guarantee whatsoever on any of the potential impressions that anybody read the story, correct?
That's correct.
And there's nothing that any of this that tells us that what was in the story, correct? Other than maybe these terms.
Can you repeat that question?
Sure. And there's nothing in any of what you've provided to the court that tells you what is in a story other than the terms that you were asked to search for. Is that right?
I'm sorry, I'm still a little unclear on what you're asking.
Sure. In the data set that you gather, well, strike that. In the exhibits that you've put together, Exhibit A that you testified about, and then Exhibit B that's on the screen now, There's nothing in that that tells us what the substance of a story is, other than it had certain terms in it, correct?
That's correct.
Ms. Saucier, have you ever testified in court as an expert before?
I personally have not, but others in my company have.
All right. And with respect to this particular exhibit and thing, what work did you do on this project?
I filtered and collected the data that we utilized in share of voice chart, and I also filtered, collected, and produced the first part of the chart that was produced on the platform.
Yeah. And then what, if any, sort of quality control was there done to determine whether or not you pulled the data accurately?
I'm just trying to think of how to answer that. So I'm trained on the platform. I know how to filter through the data, and I filtered through that data accurately. The data, the parameters that were in the keywords and search terms are set up accurately.
Yeah.
So that gives us accurate results.
Okay. And have you ever used Westlaw, Ms. Saucier?
Not personally, but I'm familiar with. I know what it is.
So is the process you're describing sort of similar to running a search in Westlaw, and then you get a certain number of hits, and you know that search term actually produced those number of hits because that's just the way the software works?
Similar. There's a little more to it than that, but that's a decent summary of how our systems, our software may work.
If I'd have just one moment, Your Honor.
Yes.
All right. Thank you very much, Ms. Saucier. Hope all is well in Chicago.
Thank you.
Thank you, Ms. Olson. And you're not seeking any questions, Mr. Okay.
No, Your Honor.
Mr. Rudley is saying no. Anything to follow up? Because then we're going to take a break. You want to follow up on any questions there?
We're good, Judge.
Okay, excellent. Thank you, Ms. Saucier. You can be excused. Hello?
All right.
Oh,
Hello?
I'm getting an echo somewhere.
Oh.
Okay, from you, Ms. Saucier, you're excused. You can stay on if you want, but you probably have other things to do. So thank you for being here today. We appreciate your answers. So thank you.
Thank you.
Okay, take care.
You too.
Okay,
Bye-bye.
we're going to take a 10-minute break because I think some people need that. So we'll see you back here in 10 minutes. We'll say 3:20. Thank you. Thank you. We are back on the record. State versus Bryan Kohberger, CR 29222805. We just took a break. Everybody I identified previously are still here in the courtroom. And let me go to you, Mr. Logsdon.
One more witness, Judge.
Are you sure?
Just one.
Okay. Is that going to take, how long is that going to take?
Judge, I'd love it to take like 15 minutes, but it kind of depends on how things go.
You're right. We never know. Okay, so who is your next witness?
It's Dr. Amani El-Alayli.
Amani, can you spell that last name, please? Yes, well, I'm going to swear you in here. Go ahead. Raise your right hand, please.
Do you solemnly swear the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Okay, thank you, ma'am. Go ahead and have a seat there. And then once you're comfortable, please state your name and spell your last.
Sure. My name's Amani El-Alayli. Thank you. My last name is spelled E-L-A-L-I. All
right, thank you. Okay,
Doctor, can
go
you
ahead.
tell us how you're employed?
I am a professor at Eastern Washington University
And a professor of what?
of social psychology.
And what kind of education did you need to get that position?
I have a PhD in personality and social psychology with a focus in social psychology.
But what did you have to do to get that PhD?
I had to do a thesis and a dissertation, and I had to publish papers, and I had to take coursework in the area.
Where'd you go to school?
I went to Michigan State University for graduate school.
And how long ago did you graduate?
I graduated in 2002, I believe.
And how long have you been a professor?
For about 20 years at Eastern and a year before that at University of Florida.
Why are you here today?
I'm here to comment on how media publicity can influence potential jurors in their decision-making on a case.
Is that something that you normally study?
It falls within the scope of social psychology, and I do research on how bias affects judgments of people.
So when it comes to what we want to talk about today, pretrial publicity, what are the ways in which that affects the people that are watching it, who might go on to become jurors, witnesses, et cetera?
Yeah, well, they've been studying it for quite a while, since the 1960s, and across the whole collection of studies, it seems that, it seems pretty clear to me, because they've done studies where they've actually combined all the studies together to look at an overall effect. And what we find is that when people are exposed to pretrial publicity that is prejudicial against defendants, so anti-defendant pretrial publicity, that it does affect guilty verdicts even later on after the submission of evidence and arguments.
Can you give us a little bit more information about that? I mean, what sort of materials does a person need to see, and what have they been able to tell us about what it takes to be prejudicial pretrial publicity?
So what kind of information would you need to get exposed to?
Right.
Yeah. Really, anything that is anti-defendant could potentially carry weight, but some information might carry more weight. And I know because of the present purpose today, one thing we're wondering is about experts, authority figures, and their type of evidence that they provide and arguments that they provide pre-trial, and how those can carry added weight. And in my field in social psychology, we've studied for a long time the fact that people who have expert status are listened to more, people who have authority are listened to more. You know, we're raised to trust that people such as police officers will know more than us. And so when we see information that's presented by somebody who has status or expertise, we tend to trust it pretty readily. And a lot of the time, the publicity about a case, it supplies negative evidence about a defendant or negative arguments about a defendant, and a lot of the time that comes from people like criminal investigators. And so if those are people that we're listening to more, then that could carry more weight potentially.
Now you've heard there's been some discussion of other ways that we could try to deal with that bias. One of those would be jury screening. What do we know from the studies that we can do in a voir dire situation, or that we can't accomplish via voir dire, to take into account the issues that you're talking about?
Yeah, it's unfortunately really difficult. So, you know, one thing that they try to do is try to select people who haven't been exposed to publicity. But it's hard to know what you've been exposed to. It's hard to remember everything that you've been exposed to. So a lot of the time we have memories that are unconscious, that we don't know are there, but have affected our judgments of somebody. So I could read some articles, and they could have some anti-defendant information, and then I might form a specific impression of the defendant, and I might forget the information that led to that impression. But what happens is that impression colors other incoming information. And so I actually evaluate other evidence consistent with my impression that I formed. I pay more attention to information that lines up with the judgment that I made. If I decided somebody's guilty, for example, I bias information in that direction. If it's ambiguous, I process it differently, I remember it differently, et cetera. And so most people aren't aware of this. And so if they don't know what knowledge is in the back of their minds and they don't know how that knowledge can affect their judgments, then it would be really hard, probably impossible, to ask somebody if they've been exposed to information or not and have them have a totally accurate response. And they would especially be inaccurate if you ask them if they're able to set their bias aside and evaluate something in an unbiased manner. And my argument, and a lot of social psychologists in the field would agree, if not all, is that if you say you have no bias, then that's kind of a limiting factor to being able to correct for it. And so if we select people who say that they're unbiased, those might be people who actually potentially aren't going to make corrections and try to be really objective because they feel like they're already fair. But our default is usually to be biased.
Can I just interrupt?
Sure.
If you could slow down.
Oh, sorry
a little
about
bit
that.
because I just watched the court reporter and she was going a million miles an hour. So, but
I think
thank
I
you.
was responding to your comment about time, but
No,
but
hey,
I'll
look,
try to
we
slow
have
down.
all the time in the world.
All right.
This is important. So go ahead.
Sure.
So one of the things you mentioned was telling people to set their biases aside. A lot of judges, not necessarily this one, love to ask jurors if they can be fair after they just told us that they have a bunch of biases. And then they say, oh, sure, but I can be fair in this case. What does the studies tell us about that?
Yeah, unfortunately, if you look at most people, we tend to acknowledge that other people are biased, but don't acknowledge our own biases as much. So if we aren't able to see our own biases, then we're going to be able to think that we can be more objective than we can. And it really takes a lot of discipline and a lot of effort, and you also, as soon as you let your guard down, the bias seeps through, and you can't help but let your guard down. So once you're a little tired or distracted or something like that, then bias kind of dominates people's perspectives. So while people are well-intentioned in saying they can set their bias aside, and I think they take it seriously and really want to, it's extremely difficult.
And I'm sure this question will probably come from somebody, but we've been talking mostly about things that would be prejudicial toward guilt, but did all these very same things go towards innocence?
Yeah, so potentially pretrial publicity that favors a defendant could alter judgments in the other direction. Is that what you're asking?
Yeah. Do you have any thoughts about what the court system can do to try to prevent people from becoming biased about a case like this one?
Yeah, there's all this research on trying to figure out how to mitigate the bias that's naturally there because people are getting exposed to all of this information and then serving as jurors, but we haven't really nailed down a good solution after the fact. So it doesn't go away, it seems like, when evidence is presented and arguments are presented. It doesn't go away as people go through trial. They still have their biased judgment in the end because it served as that filter, where everything coming in is getting distorted based on expectations and opinions at the onset. And it doesn't go away, like I said, with jury selection, voir dire. It doesn't go away with deliberation. In fact, sometimes when people interact as a group, their bias gets stronger if there are some people leaning in a certain way. And then there's evidence showing that if you have a group of jurors where some people were exposed to pretrial publicity and some weren't, that can kind of spread to the jurors who were not exposed, so then they sort of get contaminated. So the problem is we don't have an after-the-fact solution yet, and so my thought is to prevent that bias in the first place.
Are you prepared a report for this case, is that right?
I did.
And you've seen that I've slapped a great big letter E, no, D, letter D on it. And is that the report that you prepared?
I don't recall the letter, but it does have my name on it.
Can you see the D from where you're sitting?
Maybe open up to this first paragraph or first
Yes.
page. There you go.
That is
that
my
you?
report.
And is the Exhibit D true and accurate representation of the report that you prepared for this matter?
Yes, and it's very much research-based.
Your Honor, I would move to introduce Exhibit D.
Your Honor, I would object. I mean, I don't think there's any foundation other than this is basically a research report. And it's certainly not appropriate expert testimony or expert report. but given the court's indication that it wants to hear all the evidence, if that's my objection. It's essentially a research report, not a appropriate expert report or testimony.
That's an objection, but you just want me to admit it? I can't see you now.
Yeah, I defer to the court, Your Honor.
Okay.
I object to it.
Okay, look, I mean, I'll overturn, or I will admit that, and I'll overrule the objection. Again, understanding that one of the reasons I'm doing that is to just create a record for Mr. Kohberger and dealing with, the potential order or vacation of the order, the current order, and I think that is important, particularly in this case, to have that record. So, also, we had testimony and that it can be cross-examined here today. So, I'm going to admit Exhibit D with over objection. Thank you.
I have no further questions.
Okay.
Thank you.
All right. So, Ms. Olson, you have an opportunity, of course, to examine the Exhibit D and cross-examination.
Thank you, Your Honor. Good afternoon, Professor El-Alayli. My name is Wendy Olson. I represent the intervener. I represent the intervener defendants in this case. And Professor, you also provided to Mr. Logsdon a CV, correct?
I did.
Is that part of what you offered as Exhibit D? Then I would offer, I guess, as Exhibit E, Your Honor, what was identified as Exhibit E attached to Mr. Logsdon's filing from Tuesday, June the 6th.
No objection.
Okay, but what is it?
It's her
CV.
It's her curriculum vitae.
Okay, that will be admitted without objection. Thank you.
And Professor El-Alayli, is that a current and accurate copy of your curriculum vitae?
As far as I know, unless I forgot something.
Well, you prepared it, right?
I did.
And you gave it to Mr. Logsdon, knowing that he was going to provide it to the court, correct?
Yes.
And you would agree with me that there's nothing on your curriculum vitae about any work you've done regarding jury bias, correct?
Correct. I have not specifically studied jurors.
And this is the first time, I take it, then you've been asked to testify or provide a research report regarding that, correct?
No, I've done it before.
Okay, and that's not listed anywhere in your curriculum vitae, correct?
Correct.
And so if I looked at your curriculum vitae that you've submitted, I can't use that to go back and talk to other lawyers or other tribunals that might have heard your information, correct?
Not from the vita alone.
Okay. I would have to get that information some other way. How many other times, is that yes?
That was a yes.
Oh, sorry, yes.
How many other times have you done reports on jury bias?
Just once.
Okay, and when did you do that?
About 2016 or 17.
Okay, and what was the nature of that work that you did?
It was for a change of venue, a similar circumstance, but different.
What was the case?
It was the Renfro case.
And that was done by the Kootenai County Public Defender's Office?
Yes.
And was that also with Mr. Logsdon?
It was.
Have you ever done any work related to juries other than that?
I haven't.
Okay. What work did you do to put together the report that's been admitted by His Honor as Exhibit D?
Well, I reviewed the relevant literature, and of course a lot of the research I already knew about and described in the report, put it together in a way that I thought explains all the potential problems of how publicity can affect judgments of guilt.
So you did research and you wrote a report, is that correct?
Correct.
And Professor, you described some impact of like biases that potential jurors might have, correct?
Yes.
And that could be true in any case in the criminal justice system, correct?
Sure.
Nothing unique about this case?
Well, it's got a lot of publicity.
Well, nothing unique about that, how that process works in this case.
Could you rephrase? I'm not sure if I understand.
Sure. The kinds of the biases that you've described and how members of a jury might be biased, that could occur in any criminal case, correct?
Bias can occur in any criminal case.
Right, and that particular process that process is not unique to this case, correct?
Correct.
All right. And one of the ways that a jury might get biased as a criminal case or potential jurors is they walk in the courtroom and they look at the person who's sitting at the defense table, right? That's one of the things that you've studied.
Specifically looking at somebody?
Knowing who the defendant is, right? If someone's sitting at the defense table, they're like, that's the defendant. That's the person. There might be some bias that gets filtered that way, correct?
By recognizing that they're the defendant? Yes.
Yes. Okay. And that can happen in a criminal case, correct?
Yes.
And you've, I think, acknowledged in your testimony that if there's pretrial publicity that is favorable to a defendant, that almost also might influence how jurors approach a case, correct?
Yes. There's less research on it, but they have found that to be the case.
You've read, in your research, you've looked at a lot of things, correct?
Correct.
To write the study, the report that you wrote.
Yes.
And Professor, when you're talking about sources of information and that experts tend to be listened to more, I mean, that's one of the things that you're hoping happens through your testimony today, right? The fact that you've been designated as an expert, the court's supposed to take that and give your testimony more weight than somebody else's, correct?
Yes.
Right. And that's a bias that Mr. Logston is certainly hoping the court takes here, correct?
A bias?
Right, that the judge will have a bias towards someone who's an expert and weigh their testimony more heavily. Isn't that part of the purpose of your testimony here today, Professor?
I don't know if I would use the word bias, but I understand what you're saying.
Well, he would take your word more authoritatively because you have written a research report as an expert. Is that right?
Yes.
And Professor, with respect to other methods of ensuring or trying to limit the impact of pretrial publicity generally, you would agree that passage of time may reduce the amount of exposure that someone might have to publicity, correct?
The amount of exposure or the amount of bias?
Either.
I can't comment on how much exposure. I'd leave that to the media people. With regard to bias, we don't really know that yet. There are some studies that suggest that some bias can get stronger over time, and some suggest it can get weaker.
So with respect to that factor, you're not telling the court one way or the other then about the impact of the passage of time, correct?
Correct.
And in the passage of time, too, wherever the trial is located, people might move to that city who are completely unfamiliar with the case, correct?
Correct.
All right, that's all the questions I have. Thank you, Professor.
All right. Thank you, Ms. Olson. Any redirect?
One moment.
Oh,
Your
Mr.
Honor,
Rudd.
sorry, we
Hey,
may
Your
have
Honor,
more questions.
I apologize. I neglected to ask one question, which Mr. Carone reminded me of.
Okay, go ahead.
When did the Kootenai County Public Defender's Office hire you in this case?
Formally, let's see. I was approached in early May.
How about
the date of hire? Is that when I signed?
How about informally? When were you first approached in this case?
First approached in early May.
Okay, thank you.
All right, thank you, Ms. Olson. Okay, thank you. Mr. Rudley?
Thank you. Just briefly, good afternoon, Doctor. In your report, you emphasize the impact that authority figures' statements have on bias. Is that correct?
I did.
And one of your conclusions is that limiting statements by authority figures is a good way to address that bias?
It would certainly mitigate some of it.
Thank you.
Thank you, Mr. Rudley. Okay. Any further questions? Any redirect? Thank you, Mr. Logston.
Did I ever tell you that I think that the judge would be biased because you're an expert?
No.
Didn't think I said. Okay. No further questions, Judge.
Okay, thank you. Okay, may this witness be excused?
Yes, Your
Mr.
Honor.
Logston. Okay. Any objection?
No objection, Your Honor.
Okay. All right. Thank you. You're free to stay. You're free to leave. Thank you. Thanks for your help today. Any any other witnesses?
No more witnesses, Judge.
Okay, excellent. Are we ready to go to argument then? Okay. I guess Ms. Olson already had her argument. Do you want to make a further argument now based on the testimony before we go forward with Mr. Logsdon's argument?
Your Honor, I'm fine making my arguments at the end based on the testimony. I don't think it changes any of our arguments for before. It's our position that the experts that were proffered, the witnesses that were proffered by the defense are not experts and should not be considered as such, and they certainly offer nothing about whether or not there's been any prejudicial pre-trial publicity. Thank you, Your Honor.
Thank you. Okay, Mr. Logsdon.
Your Honor, we are objecting to the dissolution of the non-dissemination order. Obviously, we liked the concept. That's why we stipulated to having one in this case. And I think we've made it clear what we're hoping to communicate is that when you have something of this gravity, a courtroom is the appropriate place to air out our differences and to come to resolutions. The media is not a good place to do this. I don't know if the media ever was, but certainly the media of 2023 is not a particularly good place to go when you're trying to resolve issues rather than simply take them and make them worse. In terms of the legal basis for a non-dissemination order, as we pointed out, there are two bases. One is simply the ethical rules, which we argue are always in effect, and that this court can, with or without any kind of an order, use those to rein in not just attorneys, but essentially the parties in the case. And we believe that the Gentile case speaks to that. Chief Justice Rehnquist specifically talks about the needs of those who come to court and appear in court respect, at the very least, the sorts of things that are contained in our Rule 3.6. We obviously spent quite a bit of time using Comment 5 because, frankly, it's just better written and not. I think if you were going to make a vagueness challenge to 3.6, which some people have made, it's not the best. But I think with Comment 5, it makes a certain amount of sense. The second part of the order, which has actually become the first, is essentially what's termed a no-comment order, and that's what everybody seems to be up in arms about. I mean, in just about any other case, would probably agree, but in this case, with the way that things have gone, I think that the no-comment order is helpful. The reality is, if you take a look at what we now have in the record, is just an enormous amount of press. Your Honor has the ability to take judicial notice of what's going on out there and the temperature in the room. I think the court has noted that it's pretty one-sided. The push here is to try to show in every way possible that the state has it right and this is their guy, and the question is just how long before we can get him to a firing squad. I mean, it's grotesque, and that's essentially what the press has been up to, and it's been disheartening, but mostly it's just concerning from the standpoint of when we reach out to witnesses that we want to talk to, nobody wants to talk to us. Nobody wants to be the person to burst the bubble of the mob that the media is forming in anticipation of what they think is coming in this case. So when we say that the standard is substantial likelihood of material prejudice, this case has gotten to the point where I could tell everybody that my client uses a blue toothbrush and suddenly that would become materially prejudicial to him. They will find a way. Since I spoke this morning, they have already found ways to say that the fact that he stood silent because it's a legal strategy is somehow a bad thing. I mean, that's what they're doing. So everything is getting twisted. At the very least, what we can do is send a message to the public that, we're not going to go out and hold interviews. We're not going to have detectives sitting down and going through evidence that's not coming in at trial. We're not going to do that. This is a system. It's worked for hundreds of years. This is a nation of laws, not men, and this is how we do things here. And so if you're going to behave in this way, in terms of the kind of coverage you guys do, the substantial likelihood is there, the material prejudice is there. And so it's just a circumstance where we, as officers of the court and court participants, need to be cognizant of the fact that that's the way the media is behaving, and we shouldn't be speaking with them at all. There have been a number of sort of, to me, kind of odd questions about some of the exhibits we put together about authority figures. I mean, that's a subject that we came up with because that's essentially what the current non-dissemination order does. The current non-dissemination order is aimed at court participants. In other words, they have the authority because they're part of the case. They have access, as the court has noted earlier, to witnesses, to things that could be evidentiary or may or at least seem evidentiary. And when we speak, we have a bigger impact on things. The reason why we put together a graph that shows Shannon Gray compared to Ms. Boone was nothing to do with the fact that she's an AP reporter and therefore obviously puts out a lot of stuff. It was to show that the number of, whatever they call them, potential impressions that she has, or Ms. Coffendaffer, who's a pretty well-known commenter on this case, is just nothing compared to Mr. Gray. I mean, when Mr. Gray speaks, people listen. And he pales in comparison to the FBI or the Moscow Police Department, but I mean, the attorneys and our agents and the witnesses, we're the ones that everybody wants to hear from. And so when we talk, people are listening. And so it matters to have us abide by the ethical rules. And if there are those of us that won't do that, I don't know that the court has any. I mean, the court obviously could do various things if somebody's not willing to abide. But having just a non-dissemination order that says, stop talking outside of the courtroom, I mean, it seems to us that it's working. Because even though the media continues to do what it's doing, we don't suspect anyone's going to be able to turn that around. But we would also hope that when we come to voir dire and we're talking to a possible jury, people are going to go, well, I'm aware that there was a non-dissemination order, so I know a lot of the stuff that I saw in the press may not even have been accurate. I mean, the public in 2023 has become very aware of the fact that what they read in the papers may not be the truth. We have sadly arrived at that point. Journalists do not have the credibility they once did. So when we deprive them of the information that they're just going to twist around, then at the very least what we do is we deflate that credibility. And we make it so that the stuff that happens here and now is the stuff that people are going to be listening to and hopefully spreading and talking about and thinking about. I mean, we can only go so far to make this a fair process.
Can I interrupt you for a second? Because that's what the media, that's what Ms. Olson is arguing, that if you get rid of the order, then they'll have access to more accurate information, and that'll take care of the inaccurate information.
Yeah, I got that.
It'd be nice.
So the idea, I guess, is if the media just had access to Mr. Kohberger, we could have all of this cleaned up by tomorrow, right? If he would just talk.
I think we're thinking more about prosecutors, law enforcement, and even your office.
Yeah, I'm sure that makes perfect sense to them. But I think we also know that the reality is that if they spoke to us, they will pick and choose from our statements. They will twist what we said into things that we never meant. And they will continue to put on the same narrative that gets them clicks, as they say, or makes them money. I mean, there's no way that we can somehow provide them with information. And aside from that, I mean, I can't imagine that Mr. Thompson is any more thrilled about the idea of me sitting down to tell journalists my side of things without him being there than I am about him doing the very same thing. That's why we have a courtroom. Come here. We do it here, in front of each other's faces, so that each one of us can get up, have our say, Your Honor, or the jury can make the ruling. The idea that somehow things get more accurate because it's not even accuracy, it's just speed. It's just how quickly can they put something into the next news cycle. Because they're going to get all the same information in this courtroom. And they'll get more accurate information because in this courtroom, you get to hear from everyone and not just some particular side and what it is they're trying to sell to the media. So the idea that somehow, if they had access to the police or Mr. Thompson, that we're going to get better reporting is ludicrous. And that's not how the real world works. Also, we just wanted to remind everyone, if this case were to be a death penalty case, the jury is the one that would be deciding the sentence. So the idea that somehow there's like a difference between pre-conviction and post-conviction, like who's a witness and everything else. We heard a lot of that this morning, and maybe it's just good to remind everybody that we're concerned about who's going to be sitting on this case for every aspect of it, and that's going to include, should it be a case about capital punishment, who the jurors are going to be that sit for that as well. So it's not like, our concerns stop if a conviction occurs. So, Your Honor, I know that we submitted a rather lengthy briefing, and I know that it's getting late, and I'm supposed to make it to a ballet recital. So, unless the court has any further questions for me, I think I'm done.
Great. Thank you, Mr. Lawson. So, Mr. Radley, you're coming up. Okay, go ahead. Thank you.
Yes, Your Honor. Now, be brief. The state largely concurs with Mr. Logston's analysis as to the reasoning why we see the amended non-dissemination order as being effective in this case and as being an adequate response to the court's duties under Shepard v. Maxwell. We also thoroughly briefed the issue and would ask that in addressing the media's specific motion that the court apply the test in Radio and TV News Association, which is cited throughout the Supreme Court's brief in the issue that, or in the other case, that looks at whether the incidental effect of the order restricting the speech of the attorneys in the case rises to the level of a First Amendment infringement. And in that case, the court used the test that examined whether the restrictions imposed were reasonable. Whether the restrictions imposed are reasonable and whether the interests of the government override the very limited incidental effect of the order on First Amendment rights. There's not a constitutional right to interview, as the U.S. Supreme Court's noted in Pell v. Procunier. And in this case, while there are First Amendment interests that are balanced with the Sixth Amendment, the order's incidental effect on the right to ask questions doesn't rise to the level of an infringement. No one's saying that this case will be tried behind walls of silence, as has been said. We're simply saying that the case will be tried in this court. Thank you.
Thank you, Mr. Radley. Okay, Ms. Olson, it's your motion, so you have the last word there.
Thank you, Your Honor. And perhaps I'll start with the point that Mr. Rudley was sort of finishing on with respect to talking about court orders and who's involved. Well, there is state action here, respectfully, Your Honor. When a court enters an order, there is government, there is state action, and so that's different. And we submit that because of that, that the court has to, in imposing that order and restricting speech, it doesn't impact the right to interview, it restricts the right to gather information. And so we respectfully disagree with Mr. Rudley's description of how that right is at issue in this case. And I think, Your Honor, I respect that Mr. Logsdon is angry at the press, and that he feels that the press is making his job more difficult. But certainly we're not arguing for that the rules of professional conduct do not apply. So if the court vacates the amended non-dissemination order, the rules of professional conduct would still be in place. And I would not expect that Mr. Logsdon or Ms. Taylor or Ms. Massoth or Mr. Thompson or Mr. Rudley or Jeff Nye would sit down with the members of the media and provide to them the information that Rule 3.6 prohibits them from making. But what it might do is, if there is a question about what went on in the courtroom today, and Mr. Logsdon referred to, I guess he checked the social media or whatever over the lunch hour or on a break or whatever, and said that there were still people who were getting wrong, I guess, the comment he made about why they instruct their clients not to enter a plea and to have the court enter the plea with them when there's been a grand jury indictment. Well, if there were not an amended, or there were not the amended non-dissemination order, then a reporter could ask Mr. Logsdon that clarifying question on the way out of the courtroom. Mr. Logsdon, I'm not sure what you meant by that. Can you please explain that to me again? And that would certainly help the reporter. It would help the public to whom that reporter's story or tweet or whatever however they're getting out there does, better understand the process. I understand the frustration that everybody has with the media that is reporting things that, frankly, the gag order is having no impact on the things that we're all complaining about. No impact on that. And I understand that. But I think among the other things that the positions taken by the parties in this case ignore is the very important role that the media has in properly educating people about the case. And yes, it is the obligation of members of the media to get the story right. And as a former public official, I can guarantee you that the times the media doesn't get it right are super frustrating. But that will happen all the time unless there is some way to help the media get accurate information. And that is not to provide details about the case, but maybe to help them understand the process better. And I know we have the motion coming up on cameras in the courtroom, but I honestly think Mr. Logsdon made the argument for having those better than anybody could. Thank you, Your Honor.
Thank you, Ms. Olson. Are we prepared to go ahead on the cameras in the courtroom today? Okay. So who wants to go first? Okay.
I'm happy to go first, Your Honor.
Go ahead, Ms. Olson. Yeah, I mean, I asked for a briefing. I've read the briefing, and I think, I mean, I have discretion. There's no question about that.
Yeah.
Under Rule 45, and it's really dependent so much on circumstances, in my opinion, and kind of where we are at some point. Obviously, I agreed to have cameras in the courtroom today. I've never denied having a camera in the courtroom through, I was 10 years as a magistrate and now almost 5 as a district judge. I believe in that, but this is a different case. And so when we look at other sort of circumstances where it might make sense, this case really is different. And of course, both sides look at the Daybell case and the decision that was made in that case. So that's my preview. So, but I'm open-minded about this, and what's frustrating is just how the video, it's not necessarily problems in the courtroom, it's what the media does with the videos, with the photographs. and how it's sort of manipulated in some way that is harmful, in my opinion. So, go ahead. Thank you.
Thank you, Your Honor. And first of all, thank you on behalf of the interveners for allowing us to provide input on the court's exercise of discretion on this particular matter. And I think we submitted both our opening brief and a reply brief on this. But what I would hope to leave the court with is the need. This is a case that has impacted this community in many, many ways. And the people in this community, we believe, should have an opportunity to observe the proceedings as they occur. And not everyone is going to be able to make it into the Latah County Courthouse, and certainly if it gets moved somewhere else, it may become more complicated.